Page attention from admission. Page number 8, serial number 35 to 40.
Serial number 37.
Serial number
37.
30?
37. 10%.
Here part.
I have to file the assessment.
The request of learn counsel for the petition. Inform the other side. Go for the respondent. At the request of learn counsel, the respondent lists this matter on 11th of December. Yes, next.
Page number 9, serial number 41 to 49.
Serial number 44. Next week.
40?
44. For the petition.
No, anyhow, the other side is already, the notice is served to them, we'll hear it. This is matter on 17th of December. Yes.
Page number 10, serial number 50 to 56. Page number 11, serial number 57 to 63.
63. Yes. 2019. Yesterday's matter, I think it has come up on the last occasion also. It is coming up for the first time. It has come up in the list. It's a date given matter.
Date given.
No, but it's a 2019 matter. Court is not inclined to adjourn it. No, but, it's an unreasonable request. List this matter on 9th. No further time would be granted. At the request of learned counsel for the respondent or the respondent. Yes.
Serial number 58.
58.
58. Other side is informed.
H.
There should be a reason for asking adjournment. I'm tired of telling the same thing every day. It's unfair on your part, unless and until there are substantial reasons for seeking adjournment. And I'm feeling embarrassed to, refuse the request of the advocates. That's why I'm considering. You appear for whom? At the request of one counsel, the petitioner. This is matter on 12th of December. No further adjournment. Yes.
Page number 12, serial number 64 to 70.
Serial number 64, my discussion was just today. The second one.
Right.
And last time,
This reaction will open?
CRP has to be allowed. I have told my lord to the respondent that it will be allowed. My lord, they have requested to seek adjournment so that they want to change my advocate. You also have a second, my lord, if they don't come, my lord, I will give them.
This is matter on 10th at the request of one counsel, petitioner. No further respondent. No further adjournments will be granted.
Serial number 68, madam. For petition.
Yes.
Next week. Serial number 60, next week.
60.
My senior is not feeling well.
For the petitioner.
Yes, madam.
At the request of one counsel, the petitioner. This is matter on 18th December.
Serial number 67, madam. This case under petitioner. I have handed over the NOC Wakala petitioner.
And which matter?
67.
67.
We wanted to engage some other concept. We need a week's accommodation. Any day.
Then counsel, the petitioner submits that. Then you have to file the memo.
And that's why I will
It's
file
submitted that the petitioner has given a wakala to this matter and we'll come up with the memo. This is matter on 16th of December.
please.
Yes.
Not serial number 43, not for respondent was pivoted. Not feeling well, we lost 2 days accommodation.
40?
43.
Pankaj Asremat.
Huh?
2 days accommodation.
Yes, this is matter on Thursday. Yes, yes.
28.
A week's time, report order. Yes.
Seal number 2. Shall I read
Side before order. Next.
Non-compliance of office subjection for second time. Seal number 3.
Next time before order.
Seal number 4.
A week's time before order. Next.
Seal number 5.
A week's time before order.
We have already given NOC in this.
Come up with a memo. Then counsel the petition submitted, they've already given a wakalat. List this matter on 29th for filing memo of retirement. Yes, 6.
Seal number 6. Another will be open.
No representation for dismissal tomorrow. Yes,
Seal number 7.
Week's
week's time, 8.
Week's time.
Each time before order, and both the matters 7 and 8. Yes, 9.
Third time. Seal number 9. Partial good.
A week's time,
That's a
a week. You will do it in the due course of the day. Then counsel submits that, he will comply the office subject in the due course, which is the course of the day. Yes. Next.
Seal number 10. Sir, Dhirana.
A week's time. You appear in 10?
Sir, Dhirana.
This one no supposed to also appear.
What is his name? PK.
Yeah, no.
SR Hegde and Associates.
We have given NOC.
You are given.
Yes, ma'am.
Land counsel submits that, representing Ms. SR Hegde. They have already given up wakalat, and other counsel has already filed wakalat. Delete the name of so and so. No representation for the counsel. List this matter for dismissal tomorrow. Next. Next.
4 times. Seal number 11. Non-compliance of office subjection 4 times.
No representation for dismissal tomorrow.
6 times. CID.
We comply during the course of the
No, first of all, what is the maintainability? That's the point. When then ask your senior to come.
First.
Not pass over, list it tomorrow.
Tomorrow.
Yes, next.
Announcement. Seal number 30. Algar Swami Dhirana.
Take that memo.
being discussed.
It is memo is filed, seeking dispensation of notice to respondent number 4. Memo is taken on record and notice to respondent number 4 is dismissed with at the risk of appellant. Next.
Seal number 40. Surajas Brewery.
And for petition, allowed some
Yes.
Insufficient address.
But my lord, in the criminal misdemeanors I filed for maintenance, there I have given the same address, my lord. There it is served and they are represented by the respective council.
Then why don't you take notice to the council appearing before the trial court?
Please,
Then council of the petition is permitted to take out notice of the council appearing for this format before the trial court and file a memo to that effect. This is matter on 10th of December. Yes, next.
please.
Seal number 50. Mahanteshwar Sriram.
Weeks time adjournment, I will take
A week's time, finally, default order.
Please.
Seal number 60.
No
Anandar
representation,
Padi. Anandar Padi. Seal number 60.
no representation for dismissal tomorrow.
Seal number 70. DC Jnanaya Swami.
No representation for dismissal tomorrow. Yes.
Seal number 80. SP 100.
We can be dismissed.
Hmm?
Petitioner is not coming to pay the amount. As per order, it is 712. Matter may can be dismissed.
This court by interim order dated 7/12/2023 directed the petitioner to deposit the amount. When counsel for the petitioner submits that the amount is not deposited so far, and in spite of the repeated instructions given by the advocate, they have not complied with the order. Further, they have to pay the PF for service of notice to respondent, and the petition is not turning up, considering the submissions of the petition. This is the RPSC of 2023. He has failed to comply with the interim order, nor he is taking any steps to pay the process to the respondents. That is the matter. The petition is dismissed for non-prosecution.
Bill number 19. Sahib.
That was become infection.
Instructions. The MC is disposed of for criminal misdemeanor. When counsel the petitioner submitted the criminal misdemeanor itself is disposed of, and the petition has become instructions. Dismissed as instructions.
Regarding the conduct of the respondent, because we have taken twice a notice now. So it has written no such person in the address. But she has filed recovery proceedings. In that case, this recovery proceeding also she has given the same address. She is decided they said.
Yes, next.
Bill number 20. Suggestion Dharwad.
This case, signed summons was taken. The advocate has refused to take the summons. I will take fresh steps. Again with any.
Why not come up with a substitute service application for substitute service? We will do the purpose. What application you will file now? What is it?
I will take fresh steps. Regarding a different address. Because the address shown he has not found there. He was working there. Earlier. Now it is shown as such.
For taking steps. This a week's time is granted, telling which the petition shall stand dismissed without further reference to the court. Next 21.
21. 21.
I filed along with the hand summons along with the affidavit. The advocate refused to take the hand summons. He also address is also address the absent. The cousin of the petitioner has personally go to his office.
What has happened to the
Address the absent.
no notice to the respondent is not ordered. Respondent not delivery, addressee absent. Come up with an application for substitute service.
If my lord permit, I will take fresh notice now. It will different address also.
It will not help you unnecessarily. The matter will be stayed because it is stayed. You are okay with it. Then counsel submits that. They will take fresh steps a week's time before order.
Interim also.
Interim order only granted is extended.
Please.
Yes, next.
Hearing होना ही Bill number 22.
Yes, filed the translated copies in the which I can next. Yes, filed translated.
This is matter on Thursday.
Please.
This is matter on Thursday. At the request of non-counsel for the petitioner. Next. 23. Notice to the respondents. Yes.
Bill number 24.
Appearing for the petitioners, my lords. Copy has served to the respondent, my lords, through
Yes.
WhatsApp and through Gmail, my lords.
What is this order? Give that. IA 1 of 24.
So, recall the order dated 10/9/2024. My lords. It's more than 10, my lords.
This is the order. The order. Why you were not present?
My lords, due to technical issue, it was I was not present, my lords.
You were not present on first day. Second day?
Yes, please, my secondly, my lords. In that time, my lords, I was not well, my lords, and I have informed the colleagues, my lords. Even they are also faced the technical issues, my lords. So therefore, my lords, we cannot appear before this
No,
court,
the
my lords.
difficulty is we cannot entertain these kind of petitions. When the matter is listed for
My,
dismissal, are you not supposed to be careful? And what is the purpose of
my lord,
posting it for dismissal, passing an order? And how many people have to work on that? On all this?
my lords, in the earlier date, my lords, when the matter was listed, my lords, it was adjourned, my lords, but we were not aware about this. But unfortunately, my lords, it
Why
was
you
listed as a date, my lords.
don't check the case status? Why you, when is the question of
Yes,
not?
we have, we have checked, my lords.
Uh, no, you can't. Judicial proceedings cannot be taken so casually, and this kind of applications shall remember. This court is against this kind of applications. When the matter is called,
Kindly
one is
pardon, my
supposed to
lords.
be present before the court, and that
Please,
will
please, my lords.
you're being given a red carpet welcome to come on the next day. That also you don't oblige. And what is the big reason for this court to recall that order? I don't
Kindly, we have merits, my lords, and
with my limited experience here, what I'm observing is every matter to go for dismissal, tomorrow to be dismissed. Court do not derive any pleasure in dismissing the matters for default. And again, one judge passes an order, and the next time you will come up with this recall petition, it has to be recalled. Why? I don't see any reasons to recall this order.
my lords, please, my lords, we have merits on this case, my lords, and section 17B of the Exercise Act is not complied, my lords.
You have made out a case which should appear before the court.
Am I audible, madam?
Casually. This is a casual approach of the advocate in appearing before the court.
Am I audible, my lords?
You are audible. Is the court audible to
Please,
you?
my lords. Yes, please, please, my lords.
Yes. I'm not inclined to recall
Section
this.
17B.
Might be. I'm not inclined to recall this order. No validations are made out.
My lord, kindly have it for tomorrow, my lord. Senior will appear, my lord.
No, but this is not the way. Very unfortunate. Yes, next. This is not tomorrow.
Kindly have it for tomorrow, my lord. Senior will appear, my lord.
Yes, tomorrow.
Number 21. Authorized
Yes.
Petition.
Yes.
Matter.
Yes.
There was an order for maintenance. For the wife, 10,000 was in awarded. And there are 2 children, 3,000 each.
So that is 16,000.
After the imprimatur has been granted by the Honorable Court, subject to deposit of one of my to do my work. I have deposited 1,75,000
As per the order.
as per the order. After depositing exact balance, the court has granted. Now let's side it has been served.
Yes, they are not appearing. We'll hear the matter.
Please.
Yes. What is your salary?
I am a retired ex-serviceman.
Then you must be working.
Pardon?
You must be working.
No. Now he's
What is your age?
Well, now his age is 40 years.
40 years, why are you not working?
No, recently I got on
You get the retirement benefits.
yes, sir. For that reason, it's 6 months I produced my note. Page number 21.
Yes.
Practice Act the respondent number 1 wife, she is the second wife. Already first wife was divorced, and that petition is pending before the divisional bench for both for contempt and against that this is decree of divorce. And now my pension has not been set because of the original documents of my children. They are in the custody of the first wife. For that reason, the same reason has been given by the.
Then why are you doing these kind of things?
Well, the reason is that.
You say that you work in you're retired, you're an ex-serviceman, and what is the discipline?
Well, for that reason, it's different. When I was in the service management, this all untold happenings have been happening.
There is nothing untoward.
Wait for 20 minutes, kindly.
No. Respondent is your?
Respondent number 1 is the second wife. After the decree of divorce, my lords, I got married.
After the decree?
After the decree of divorce.
Then there is a contempt.
The reason is that, my lords, when I got married, my lords, there was no such interim order. When there was an interim order, I got it registered with the sub-register. That reason we have made for that reason contempt is pending with respect to the first wife. Now, my lords, this is pending with respect to.
So what are you going to do? How will they live?
Already I have agreed.
So now you left this wife also?
Pardon?
You left this wife also now?
No, my lords, she herself is here. I have taken the same condition. The desertion was made by the second wife. Now, the thing is that I got it settled, my lords. I have made a proposal that I was having 2 acres of land, and 1 acre, my lords, I have already left the land. Undertaken before the honorable court, my lords, I will give so and so amount. Once I receive the amount from my service payment. And now my second wife, she has filed from my.
No, it's all correct. How do they have some amount, they need some amount for the maintenance.
They should. I will seek instruction with respect to whether he has received any amount further after the interim order. Seek instruction.
Court has granted how much to the children?
3,000 each one. Now I am paying 8,000 per month.
Totally.
Every month I am paying 8. Now he is working in some PG money. I think 200 graded per day. As a security guard in PG money.
For the notice is served?
Notice is served.
We'll make it 9. We'll make the interim order is 8, we'll make it 9 and dispose it off. You're paying, you said you're paying. You're paying 8,000. We'll make it 9,000 and dispose of 3 for each.
Please.
Agreed with the orders passed and criminal miscellaneous 22 of 2021 dated 30th May 2023. The wife is before this court. Parties are arrayed as wife and husband for the sake of convenience. The respondent herein, I said wife is before this court, husband is before this court. The respondent wife had filed the criminal miscellaneous seeking maintenance of an amount of rupees 20,000 to her and also to her 2 children. It's a case that the marriage was solemnized on 24/2017 and in the wedlock they're blessed with 2 children. In view of the harassment by the petitioner and her parents and his parents, she has to leave the matrimonial home. The family court, by order impugned, had granted maintenance of an amount of rupees 10,000 to the wife and 3,000 each to both the children. While granting the maintenance, the court has observed that though the wife has alleged that the husband is having sufficient income, No documents are filed to prove the same. Hence, there is no proof of income to determine there is no material to determine the income. But by looking at the facts and circumstances, financial status of the parties, and the cost of living, it is necessary to award maintenance and accordingly granted the maintenance. Next para. Let counsel appearing for the husband submits that a husband was working in he is an ex-serviceman. Now, and this the respondent here is a second wife. After obtaining a decree of divorce against the first wife, he had married this respondent, and the first wife has filed an MFA that's pending consideration before the court, before this court. In view of all these issues, he has not received his the retirement benefits as all the documents are with the first wife. He's facing a lot of financial crisis and he's working as a security guard in a PG. He submits that the court, without any material, taking into consideration the oral submission of the wife, had granted the maintenance. It is further submitted that this court has directed him to pay an amount of rupees 8,000 per month, every month, and also directed to deposit an amount of rupees 1,75,000.
1,50,000 towards
arrears.
and 25 towards the litigation expense.
1,50,000 towards the arrears, 25,000 towards the litigation expenses, and further directed to continue to pay 8,000 every month. He submits that he has been complying with the orders passed by this court. Next para. The notice is served on the respondent. No wakalat is filed on her behalf. Next, having heard the counsel's on either side, there is a material on record. The wife had sought for maintenance of an amount of rupees 20,000 for herself and her 2 children. This court has perused the order passed by the court. In the order that is passed, there is no, the court had not recorded any reasons for that order. The court had simply, though having recorded that there is no material to show that what is the income of the husband, still granted an amount of rupees 10,000 to the wife and 3,000 each to the children. On the face of it, the order of the court granting maintenance is bereft of reasons. In the light of the interim order that is passed by this court, the petitioner had complied with the order and is continuing to pay the amount. In that view of the matter, this court deems it appropriate to pass the following order. The order of the family court in granting maintenance of an amount of 16,000 is modified and the same is reduced to 9,000, that is 3,000 each. Accordingly, the petition is partly allowed. IA number, that is a document. IA number?
IA2 of 24.
IA2 of 24 is try to condone the delay of how much?
185 days.
185 days. As there is no, it is not opposed by filing any application. Considering the reasons stated, the delay of so and so is condoned, IA number so and so is allowed. Yes, thanks.
Number 26, Bude Nagaraj. Your argument, respondent.
Are you ready with the argument also? You can argue the matter. IA number 1 of 2024 is filed to condone the delay of 114 days in filing the petition. The delay, the reasons, no notice is served, no wakalat is filed on behalf of the respondent. For the reasons stated, the delay is condoned. Yes. How much is you are for the wife or the husband?
And for the wife,
What is the amount granted?
Petitioner is the one.
Ah.
Second petitioner is the child. But on the earlier edition, the prior proposal has been wanted maintenance fee. On interim, IA number 3, trial court was ordered awarding rupees 10,000 each to the first and second. That order was challenged before this honorable. In petition number 1044 before this honorable. This honorable court used to grant an interim order to the granting of 5,000 in favor of the first petitioner and rupees 10,000 in favor of rupees 10,000 in favor of the second petitioner.
So 20,000 is made to 50,000.
So,
Then
subsequently, you know, that the petition was disposed of as become impractice because of the main petition was allowed to trial.
how can it be? Let's look at the order. Where did you say that it is infectious? Because we can only look at that, what is there in the order, but it is not there in the order that it is becoming infectious.
But my petition, earlier petition was submitted, and this order was on the last petition. 15/9/2022. So the petition.
No, that is, court also records that earlier the petition is disposed of, making 20,000 to 50,000. Now the court had made its own independent adjudication, and court felt that 5 and 10 is the appropriate amount. So why it is not correct to tell the court? Yes, what is his income? What is the material you have placed before the court?
We have produced many documents. He is real estate. That is one big book is real estate. In page 27, para number 25.
Please read.
In page 27, para number 25 of the judgment papers. Undisputedly, the respondent works in a real estate. This number reduced no out of the said real estate business. Now it is the case of the petitioner that also the properties or transferred into the name of respondent, and the respondent is getting sufficient income. On the other hand, the material is available to notice for to establish that petitioner has done a postgraduate graduation in medicine, and she attempted to run a engineering classes on siblings. The material available for this court to also narrate that petitioner was doing this 7,000 as a teacher. Right?
So, you're just reading that he is a real estate business, he is into real estate business and he is earning 50 lakhs per annum. There is nothing on record.
But apart from that, exhibits.
Yes, let's look at the exhibits.
Exhibits P14, P15, P16
Arbor of survey number 3 measuring 3.17 acres.
ROR survey number
3.15 acres.
BBMP property registration. BBMP property registration. These are model rights documents. These are the documents to show that he is the only son to his mother, father and mother. Mother has died. After the death of mother, he succeeded the property. So we have produced many documents to show that he is having sufficient income. So he did not come into the witness box. So that under those circumstances, now the trial court has passed an order, they granting 5,000 rupees to the first petitioner and 10,000 rupees to the second petitioner.
First petitioner is
5,000.
that's the wife.
Please, Your Honor.
Second petitioner is the daughter.
Because
Because first petitioner is already working. She's a
no,
postgraduate.
she is not working. She is not working. In fact, earlier the court below states that earlier to her marriage she was working. After the marriage, there is no observation by the court.
Please come. Agreed with orders passed in criminal miscellaneous number 155 of 2022. The wife is before this court. 2022 dated 2nd November 2023. The petitioner, along with the daughter, has filed a petition under section 125 CRPC, seeking maintenance of an amount of rupees 50,000 for her and rupees 25,000 for her daughter. Before the family court, though the respondent had filed his objections, but he has not contested the matter. He has not contested. He has not contested the matter. He has not stepped into the witness box. Initially, the family court had granted 10,000 to the daughter and 10,000 to the wife. Thereafter, husband has carried the matter.
Please.
The husband has carried the matter before this court by filing WP number
104089 of 2022.
right there. 1040
89 of 2022.
2022.
Please.
That came to be disposed of by order dated
2/11/2023.
that came to be disposed of by order dated 2/11/2023, where this court has reduced the maintenance to 5,000 to the wife and the 10,000 granted to the daughter is maintained. That is the interim application for maintenance. The court, by order reviewed, has passed the very same order by granting 5,000 to the wife and 10,000 to the daughter. Next paragraph. When counsel appearing for the petitioner, wife submits that before the family court, they have filed exhibits P11 to P19 to show that the respondent and the family, they're owning several properties. And in fact, properties, and the respondent is the only son to their parents. Mother is no more. Father is a retired income tax officer. When counsel submits that all these aspects were not considered by the court, it is further submitted that when the respondent has not even entered into the witness box, the court ought to have drawn an adverse inference and ought to have considered the case of the wife. Just observing that the wife, prior to the marriage, is working and earning 7,000. On that ground, the court went wrong in granting 5,000 as maintenance. Then counsel submits that the maintenance has to be the courts, while granting maintenance, has to consider several factors have to take several factors into consideration, particularly the social status of the parties and how they were living before separation, and also the income of the husband. It is submitted that by by marking exhibits 11 to P11 to P19. The wife would establish before the court what is the status of the husband. Next one. Though notice is served on the respondent has not chosen to, the no wakalat is filed on behalf of the respondent. Next para. Having heard the land counsel, the petitioner places the material on record. Before going into the merits of the matter, it is appropriate to note that the respondent, in spite of service of notice before this court, has not chosen to engage an advocate. And even before the trial court also, he has not contested the matter. In the backdrop of this, the court has to appreciate the facts of the case. Exhibit P11, I said P12, no? P12 or P11? Exhibit P11 to P19 shows the details of the property. And it's the case of the wife that the husband is the only son, is having several landed properties. Even considering the fact that the wife is earning 7,000 per month, the court ought not to have granted, the amount that is granted by the court is on the lower side. Further, it appears that the respondent husband, in a very casual manner, in spite of receiving notices, is not appearing before the court. In that view of the matter, considering the averments of the wife, and particularly the fact that the husband is having landed properties, the petition is allowed. This petition is allowed by granting maintenance of an amount of rupees 50,000 to the first petitioner, 25,000 to the respondent, particularly considering the conduct of the respondent, accordingly allowed.
Yes, upon completion, is party Malika Swami Hiraman.
Kindly pass on the notes.
No password.
Counsel on record is held up in the name of the court.
You have an interim order?
Filed a visiting application.
We'll see. Tomorrow? No representation, at the request of the counsel, the petitioner, this is marked tomorrow.
Great respect, my lord. 25,000 to the second petitioner, second respondent, my lord.
First to the first petitioner, 50,000, second petitioner, 25,000.
Number 28. The evidence. Forum evidence.
Yes.
Respondent has moved an application seeking direction.
What is that?
Lord,
I have one of 20.
Yes, I have filed that IA matter. Matter has become infructuous since his prayer sought is already been done by the petitioner long back. He had prayed for deposit of amount, and this honorable court permitted him. That's the reason I filed an IA. But trial court, what trial court is considering? Trial court is.
So let us look at the interim order.
Yes, please.
Page
Lord,
number.
in a rent proceeding, charge proceeding, petitioner, landlord files an application under section 45 of the Rent Act, seeking stoppage of proceedings for non-payment of the rent.
Yes.
I filed objection. I was a tenant before rent court. I filed objection saying that I'm ready to deposit the amount, but he is not willing to take it. This application came to be dismissed by the rent court. he prefers revision before district court. Revision is dismissed. But however, a direction was issued in the operative portion that tenants shall deposit the arrears of rent within 10 days. But the no, the counsel for the respondent, that is my party and my advocate, thought that it is, the revision petition is dismissed, and they did not bother to look into the detailed order. Later they found that a direction is issued by the district court that
yes, I remember, I heard this matter.
Lordship granted an interim order, permitted me to deposit the arrears of rent.
So what
Yes,
then?
I have deposited compliant the order.
In view of that, nothing remains. Even his petition doesn't survive.
My only prayer is,
I
To
request
deposit
them
the
alone.
amount. To deposit the arrears of amount or else to stay the proceedings.
yes, that is it. But my only prayer is, matter may be, direction may be issued to the trial court to expedite the matter.
Which year is
2010.
From
2010?
Earlier also.
So it says HRC number 20 of 2024.
No. That is HRC of 3/2010. And against that, the revision was before. HRC revision petition filed of
We'll ask you to wind it off in the next 6 months.
Yes.
I'm already possession warrant was also issued.
My request for that is, this tenant also claims to be an agreement holder. Sale of a specific performance suit is filed. OS number 218/2020.
Generally, that's what will happen in all these matters.
My only
It
request
becomes
for that
agreement order.
is, yes, I'm willing to cooperate for early disposal. Let that be a direction. That suit and HRC may be held together.
Can't be. Please come. Agreed with the orders passed in. Where is that include order?
Annexure G and H.
G and H. What is H? G is review HRC revision petition number 5001 of 2024. Where is the first order?
Page number 30.
Page number?
Page number 30.
Is the first order.
Page number 30 is not the order impugned.
No, impugned order is 38.
38.
30 is the first order.
30 is the order passed by the rent court, which is not impugned by me.
Not impugned.
Yes.
For understanding the facts.
30 is the first order passed by the rent court.
Wherein the landlord's application is dismissed.
Dismissed.
Agreed with the orders passed in HRC revision petition number 5001 of 2024 dated 13th September 2024. The tenant is before this court. The facts of the case are the respondent herein has filed a petition seeking eviction of the tenant in HRC number 03 of 2010. In that, he has filed an application under that's IA number 12 under section 45 of the Karnataka Rent Control Act, seeking an order to stay all the further proceedings and directing the landlord to put directing the tenant to put the landlord in position as he has failed to deposit the rent. That came to be dismissed by order dated 12th February 2024. The court observes that on perusal of section 44 or 45 of the Karnataka Rent Act, though the word shall be used in the said provision, which is directory in nature, not mandatory, the landlord filed the petition in the year 2010 and filed the present application in the year 2023 after lapse of 13 years. That too, at the fag end of the matter. Further, the respondent that the tenant is ready to pay the arrears of rent, but the landlord refused to accept the same and accordingly dismissed the petition filed by the landlord. The landlord had carried this matter in HRC revision petition number 5001 of 2024 dated 2024. That also came to be dismissed, that came to be disposed of by order dated 13th September 2024. In that, uh, in the first part of the order says revision petition is dismissed, and as point number 2 of the order of the operative question says that the respondent is directed to pay off the entire arrears of rent till date within 10 days from the date of order, and the tenant shall go on paying the deposit of the rent every month without single default. In the event there is any default, the further proceedings in HRC number 3 of 2010 shall stand stop, and the tenant shall hand over the vacant portion of the premises within 10 days from the first default. In the event the petition being continued to be tried, the trial court is directed to go on with the proceedings on daily basis and to dispose of the matter as early as possible. And the court has also observed that neither of the parties are entitled for any adjournment before the trial court on any pretext. Further, the party committing default at any stage of the proceeding shall not be entitled for such stage defaulted. And accordingly, point number 9 says the petition is disposed of. Aggrieved thereby, the tenant is before this court. When this matter came up before this court on 24/10/2024, this court has granted it is observed in the order dated 24/10/2024 that the land counsel for the petitioner submits that he is ready to deposit arrears of rent by 25/10/2024. Hence, this court has directed the petitioner tenant to deposit the arrears by 25/10/2024. It is also observed that if arrears are not deposited before the revisional court, the petitioner tenant shall hand over the portion to respondent herein. It is submitted that as per the submission made before this court, he has deposited the arrears. Then counsel appearing for the respondent landlord submits that this petition has become infructuous as the application that is filed under section 45 by the landlord is to stay the proceedings as the tenant is not paying the amounts. He submits that as the tenant has deposited the amount, this petition has become infructuous, and there shall be as this is a matter pending from 2010, there shall be a direction to the court to dispose of the matter as expeditiously as possible. Next one. Having heard the land counsels on either side, but is the material not recorded. As rightly pointed out by the land counsel for the respondent landlord, as the petitioner tenant has deposited the entire amount, there is nothing to be adjudicated in this petition. And in the light of the orders passed by the revisional court, the directions that are issued by the revisional court, before that, there is not, as submitted by the petition by the respondent, nothing survives for consideration. Hence, this court is disposing of the matter in the following, as per the following order. The order of the revisional court, the order impugned from point number 5, 6, 7, holds court and the trial court, as per the order, shall proceed with the matter and shall dispose of the matter as expeditiously as possible, but not later than 6 months.
But the possession warrant is also issued, so 6 months is not required.
3 months.
Yes.
Cross of PW, state is cross of PW. I just hold that, no, I want order.
6 weeks, 6 months, as expeditiously as possible, but not later than 6 weeks. And anyhow, the court is not granting adjournments as per the order of the revisional court. So it need not wait for 6 months. If it happens before also, it will happen. Yes.
Influent order, but other things are clashed.
Huh?
Influent order, revisional court order.
Yes.
It has become
Nothing to
inconsequential.
be quashed.
Point number 1 to 4.
No, I said nothing to be, only
Yes.
for as far as that order that stipulated.
You should not contend that that portion of that is not set aside and possession warrant is to be
How
issued.
will I contend, my lord? Because it has become inconsequential.
That now as the petition has become infructuous as the order is already worked out. Yes. Yes. Next. Huh?
6 weeks.
No, 6 months. If you say 6 weeks, what will happen to them? Yes.
Please.
For dismissal, seal number 29, for supplying board of petitioner.
Counsel already retired.
Sir?
Counsel already retired from.
On 19/11/2024, memo of retirement is filed by the counsel for the petitioner, and he has also placed a postal acknowledgement in support of the receipt of notice by the party. Party had received the notice on 5/11/2024, and this court has directed that we are registry to delete the name of the advocate and print the name of the party. On the matter was listed on 23/11/2024. As there is no representation, the matter was directed to be listed today on the caption dismissal. Today there is no representation by the petitioner, hence the petition is dismissed for non-prosecution. Next.
Seal number 30, Saurabh Besandu.
Seal number 30, Saurabh Besandu.
Council on record is unavailable. Council on record is unavailable.
Why is he not complying to office objections from 2023? Release this matter from the caption for dismissal. Office objection shall be complied with within a week, or else it shall stand dismissed without further reference to the court. Yes, 31.
Seal number 31, Shall Bolma.
Yes.
My lords, I am for petitioner in this matter, my lords.
Yes. Argue.
My lords,
Yes.
pertaining to the maintenance, my lords, I am for the
How much is
husband.
granted?
I am for the husband, my lords.
Yes.
Petitioner,
How much is granted?
my lords, there's some technical error, my lords. I'm not able to hear. Lords, can it be posted tomorrow? I'll come down to this.
Delete from the caption for dismissal at the request of front counsel for the petitioner. Yes, next.
Seal number 32,
RPC1,
Yes.
seal number 30, RPC1.
On 23/11/2024, when this matter came up before this court, as there is no representation on behalf of the petitioner, directed the matter to be listed under the caption for dismissal. Today also there is no representation. Accordingly, dismissed for non-prosecution. Yes.
Seal number 33, Saurabh Besandu.
seal number 33,
Saurabh Besandu.
Yes, this also for a week's time is granted for complying with the office objections, or else the petition shall stand dismissed without further reference to the court. Delete from the caption for dismissal.
Seal number 34, Gujarat Saudi.
My lord, this is a case of maintenance under section 127 of CI.
Non-compliance of office objections.
During the course of the day,
Tomorrow, if you comply today, it will come tomorrow.
much.
It is counsel the petitioner submits that during the course of the day. She'll comply with the office objections. If the office objections are complied with, this is matter tomorrow, or it's the petition stands dismissed without further reference to the court. Delete from the caption for dismissal. Next.
Admission for seal number 35, Jalga response of Dagesan.
For appealing for.
Vijay.
Yes.
No, two is for election results declared on 2/12/2018, whereas defendant number 11 to 19 came to be elected, to be declared as mother and partner. My lord, along with that, my lord, we have filed an IA, my lord, under section 92 of CPC, my lord, for leave of the court to institute the suit, my lord.
Leave of
To
the
institute
court?
the suit, my lord. Where, my lord, I have filed an objection, my lord. Where, my lord, on two grounds, my lord. My ground is, my lord, they are not a member of the trust, my lord, the church. And second ground is, my lord, this court has, that court, 11th Trend Court has not jurisdiction. But however, my lord, court observed, my that, my lord, the reasoning, my lord, at 27, my lord. Para 9, my lord.
Let's understand the facts.
Yes.
Yes.
The reason
From para 9, please speak.
yes, sir. They say that, my lord, in the written statement, my lord, I have admitted that they are the members of the.
Let's see. The petitioners have approached this court by filing an application. Read.
Sir, the petitioner have approached this court by filing an application of section 92 of the CPC containing that they are the members of the first respondent, which the church formed for the Telugu speaking Christian community. Though the defendant has categorically denied that they are not the members of the first respondent trust, but in his objection himself admitted that the first applicant was a member till 2018. My lord, they say, my lord, court observed that I have admitted, my lord. But my attention is that further, my lord, after 2018, they are not paid the membership fee. Hence, my lord, their membership has been terminated. That is my one contention, my lord. And the second contention is, my lord.
Please come. The present revision is filed. Questioning in order, passed and miscellaneous. 13. What is this? Miscellaneous 13 of 2019 dated 28, 2020. Where is your application?
Their application, my lord. That is in page 34, my lord. Along with proof, my lord, they have filed, my lord, I number 1, my lord.
Where is this objections?
My application is, my lord, as my lord.
On your objection, this is considered.
Yes, after filing an objection, my lord,
The respondents herein has sought for permission to institute the suit against the petitioners herein. It is their case that they are the members of the AVM Telugu Baptist Church, registered under the Bombay Public Trust Act. The defendants now number 2 to 5 and the other numbers appear in the PTR were elected as members of the trust for the period from 1998 to 2001. This was accepted in the general body meeting held on 1998, and it was communicated to the Charity Commissioner Belgaum under inquiry number 743 of 1998, and the same was accepted, and the names were also entered in PTR sheet by order dated 1999. And the same was registered. Some changes were made in the trust, and defendant number 6 to 10 have been nominated, and the same has got registered in the office of the sub-registrar on 1/3/2018. when the disputes arose between defendant number 1 and another section, voice number 369 of 2003 is filed. The suit came to be dismissed and counterclaim of the defendant number 1 was allowed by judgment dated 22/8/2005. But without recognition, the defendant 1 continued as secretary of the church by manipulating the documents. The elections were like stage managed by the defendants in collusion with each other by keeping the entire members under task. Accordingly, it is the case that recently they came to know that behind the back of the executive committee was already appointed, which is not in accordance with law. Hence the dot for declaration of the result dated 2/12/2018, through which defendant number 11 to 19 were elected as executive committee are illegal, null and void, and also raised to declare that the amended bylaws dated 4/9/2012 are illegal and void, and also sought for a direction to the defendants 2 to 19 to conduct such elections. The same was along with the suit, along with the suit, an application under section 92 of the CPC was numbered as IA number 1. It was registered as a miscellaneous number 13 of 2009, and notice was ordered to the respondents, and they have filed their objections. The petition herein has filed his objections. According to them, the defendant is not a member of the church, as he has failed to pay the contribution from February 2018. Further, according to the petitioner, the court has no jurisdiction to entertain this petition filed by the respondents herein. The court, by order in view, had rejected the objections filed by the petitioner herein and allowed the petition filed by the respondents. The reasons given by the court while allowing the application are: 1. With regard to the fact that they are not the members, the court had observed that
Para number 4 of 25.
para number
4. That is my note. Para number 20, sorry, my note. 27, my note. Para number 9, my note. Reasoning first point.
the court has observed that it is the objection they have stated that they have admitted that the plaintiff was a member till 2008, but since February 2018, he has not paid the membership. On that ground, the objection of the petition herein is rejected. Then coming to the jurisdictional aspect, the court had considered section 14 of the section 14 of the Karnataka Civil Codes Act, where the jurisdiction with regard to the jurisdiction of the district court, and 5 with regard to appointment of additional district judges, and relying on the judgment in case of Ganga Gil Chela versus Rasa Singh and another reported in AR 1966, Punjab and Haryana 472. Court has held that the court has a jurisdiction to entertain the matter made over to it by the district judge, unless law is barred specifically, and accordingly, the court had allowed the application filed by the respondent hearing under section 92 of the CPC. Aggrieved thereby, the petitioner is before this court. Then counsel has reiterated the grounds that were taken before the trial court and submits that the the court below had failed to appreciate all the contentions that are raised by the petitioner. Next paragraph, having heard the doubts for the petitioner, there is a material on record. Both the objections as raised by the petitioner were answered by the court, wherein the court has said that the petitioner himself is admitting that they were the members till 2018. Then coming to the jurisdictional aspect also, the court has rightly dealt with and held that the court has jurisdiction on these both accounts. This court finds no reasons to intervene. What is this? Yes, next.
Number 36. Will follow.
Grant of maintenance. The second round of application.
Yours for the husband or wife?
The petition by the husband.
How much is granted?
About 3,000.
3,000. What is your income?
Earlier, it was rejected.
No, obviously, how much
He
is your
has no
income?
income. He has no income. He has landed properties.
He has landed property.
Landed properties, those are managed by the Marathwad. This is admitted. On this ground only, earlier round it was rejected. Why file the petition before this honorable court?
Let's read what is the reasoning given by the court. Is anything to be argued or?
3,000 now he is paying regularly. He has filed maintenance for the years also.
3,000 is a very meager amount. Whatever is his income, 3,000 so he has to please come. Agreed with the orders passed in criminal miscellaneous number 4 of 2014 dated 21st December 2022. The husband is before this court. The family court by order in June had granted maintenance of an amount of rupees 3,000 each to the petitioner.
Not the
They
daughter.
have got,
They are
3,000.
not entitled till 18 years and now they are attending.
3,000 monthly maintenance to the wife and 3,000 each to the children till they attain the age of majority. Agreed thereby the husband is before this court. Let counsel appearing for the husband submits that all the children have attained majority and the husband is paying an amount of rupees 3,000 to the wife. He submits that he has no income and he has the landed properties. It is submitted that even those landed properties are managed by the wife and she is not entitled for, the court ought not to have granted the maintenance to the wife. He submits that all these aspects were not considered by the court. Next one. Having the counsel for the petition of principality not record. The amount of maintenance, as of the court had granted 3,000 to the wife and 3,000 each to both the children. Now admittedly, the children have attained majority. Now the husband has to pay only maintenance of 3,000 to the wife. The amount that is granted by the court for 3,000 is a very meager amount, and in the considered opinion of this court, there are no grounds to revisit the impugned order. In that view of the matter, the petition is dismissed. Yes, next.
Number 37 answered. Number 38. Shura just followed.
No representation for the petitioner. Counsel for the respondent is present. This is matter for dismissal tomorrow. Yes, next.
Number 39. API. Supreme Court.
Dependence petition challenging the rejection of the application filed for rejection of the plaint under Order 7/2011.
What are these two CRPs? Two suits.
Two suits, similar applications, and same order, even though they are not clubbed, same dicta order is passed in both the cases.
So what is the suit for?
Suit for injunction, madam. Suit for permanent prohibitory injunction. Seeking to restrain defendants from publishing any article or story against the one mutt called as Ramchandrapura mutt and its pontiff in either in print media or in visual or social media. That is the suit. The plaintiff claims to be the
Second suit is also of the same relief.
same relief.
Why two suits?
But plaintiffs are different.
Plaintiffs
Plaintiffs are different and defendants are different. but the entire allegation, everything
Elements
is.
are same.
Yes. My lord, the plaintiff claims to be the devotee of one Ramchandra Pramat. It is his allegation that this there was an allegation or a criminal case filed against the pontiff.
Your defendant is a newspaper.
No, we are not newspapers.
Then what is that printing and?
That we should not publish. That is the
What
allegation.
published? Who is the?
We are not publishers. We are not printers.
Balakrishna. You are an individual.
Yes, we are all individuals. We are all individuals. The allegation of the plaintiff, my lord, is that there was two criminal cases filed against this pontiff. One is under section 376 Indian Penal Code and another Post Act. They contend that both these cases are discharged. The pontiff is discharged, and the matter is pending before Honorable Apex Court. But these defendants are unnecessarily making allegations against this Mata and pontiff. They don't disclose in the plaint when they have made this allegation, in which print media or visual media or social media they have published it. Whether all these defendants are jointly making this allegation or independently they are making allegation. Nothing is stated in the plaint. No cause of action, no date is given. Even the period, approximate period when this publication is made or allegations are published in the public domain is not stated in the plaint. Absolutely plain lacked cause of action. Cause of action was not at all disclosed. With vague allegations, a suit is filed against us seeking a permanent prohibitory injunction that we should not discuss or publish any article, story in print or visual or social media.
Now,
So,
what is the reason given by the court by dismissing your application?
Trial court says, the last paragraph trial court says, whether there is a cause of action or not is to be examined in the full dress trial and not at the stage of hearing application. That's clearly contrary to Order 7, Rule 11A. Order 7, Rule 11A says, where plaintiff does not disclose cause of action, it's a case for rejection of. Having said this, if I may request the Lordship for a while to go to the relevant portion of the plaint.
Yes. Which page is the plaint?
Page number, my lord. Plaint starts from page 10, annexure A. I will invite the Lordship for a moment to para number 8, where the cause of action, separate paragraph for cause of action.
So, para number 4 deals with the matter. Then para 5 deals with
The allegations against.
that whoever is concerned with the matter.
Yes.
No, here I think it is relevant. Read from 5.
Okay. That His Holiness Sri Raghaveshwara Bharati Swamiji is discharging his responsibilities as Pithadipati of the said matter in a very fair, transparent and diligent manner. That being the case, some of the members belonging to Haveka Brahmins community conspire to dethrone His Holiness Sri Raghaveshwara Bharati Swamiji as Matadipati of the said matter and hatched vicious plans to take over the mutt and misuse the funds of the said mutt for their private ends. His Holiness Sri Raghaveshwara Bharati Swamiji was falsely implicated by one lady on vexatious and baseless charges of rape in Girinagara Police Station, Bangalore, which was committed as SC number 1242/2015 before District Assistant Judge, Bangalore. And His Holiness Sri Raghaveshwara Bharati Swamiji was discharged as innocent, and all the allegations and false evidence collected in the case were held to be baseless and vexatious. Taking this opportunity, the fringe group in Haveka Brahmana community have made and are making every possible efforts to tarnish the image of said mutt in general and image of His Holiness Raghaveshwara Bharati Swamiji in particular. The above defendants are some of the people belonging to such fringe group and are making venomous attempts in distorting the character and image of His Holiness Raghaveshwara Bharati Swamiji. The plaintiffs herein are deeply hurt and pained by the publication of false information circulated by the defendants herein through print and social media. That the allegations and venomous campaign undertaken by the defendants herein to denigrate the image and authority of His Holiness Sri Raghaveshwara Bharati Swamiji and the mutt are unpardonable and cause a long way in hurting emotional bondage of the plaintiffs with the said mutt and Swamiji and creates irreparable damage to the feelings and faith of innumerable followers and devotees of the said mutt. The plaintiffs see divinity and total sanctity in said mutt and His Holiness Sri Raghaveshwara Bharati Swamiji, and they are unable to withstand the disrespect shown by the defendants herein by defaming the mud and its holiness. The
No,
defendant says,
where is the cause of action for you to file the suit?
My lords, here, cause of action, my lords, can be, it can be, my lords, reflected in throughout the plaint, my lords.
We are looking at the entire plaint.
Please.
No, not that we are looking only the portion of the cause of action. We are looking at the entire plaint, reading the entire plaint, what has happened, when it has happened, where did he publish, how did he publish. Those are all relevant. Without that, you can't just make a bald allegation without any. There should be something. You should have narrated that he has printed so and so on so and so media, or he did so. Something should be there.
Let's say the details of the publication are not reflected in the plaint.
But that's a relevant one. If not, you should say that on so and so date they did this, or they said to somebody, or something should be there. Absolutely, it doesn't disclose any cause of action. You just narrated the facts. That's it.
That's that millards is subject to the trial. Whether millards
Then what is it? No, according to you, then one of the reasons for rejection of the plaint is not disclosing the cause of action. If that is the case, that cause of action will be seen at the time of trial, then what is the purpose of for that order 7 to 11?
No, that is not what I meant. Let's say another plaint, let's say connected matter.
Let me look at this first.
Please.
And then once if it is not disclosing any cause of action, then it has to go. Then we will look at the next plaint.
Millards here, millards are there. Although millards details of the publications and all that is not reflected in the plaint, millards there are clear specific allegations against the defendants, millards. Throughout the millards plaint.
Please point out that I want to see.
Millards, may I continue reading para 6 millards?
Para 6, please read. What allegations he made?
That millards there have been defaming millards the mud and the pond by various publications millards in different.
You know, one can't file this plaint can't be so casually be drafted like this.
Millards further at para 7 millards, defendants are misusing the platform of print and social media to spread the false information about the said mud and His Holiness Shri Raghaveshwara Bharati Swamiji, and they are continuously engaging.
Even though for this, a defendant has to file his written statement. You should understand, basing on what you are saying that he has been defaming you, how is he defaming you? Can anybody file a written statement for this? You should say he has done it. He will come up with his written statement saying that I have not done. No, you said something vaguely, you will file something vaguely. On these pleadings, can the suit be decided? That's why it is one of the grounded cause of action. Please get instructions. This will have tomorrow. What about the other things? What you are referring to in your other plaint, you are saying that it contains. Give the next plaint. Where is the plaint page number?
Page number starts from 13, page number 11.
16 millards, para 9.
Same plaint.
No, it appears to be a lengthy plaint.
No, defendants are more here. Defendants are more here. But here also, what is the allegation they are spreading is not stated. In which media it is published, not stated. Approximate period also not stated. Nothing there.
That's here in this plaint, para 9 millards, page 16.
There is no para 9 in page 16. That
182, CRP 10018.
Yeah, I'm looking at 1000181. Para 9 is the suit is not barred by limitation.
May I request your lordships to refer in CRP 1000182 millards.
First one is 181.
First one is
That I've
181.
already seen. That I've already seen.
My millards, the para 9. There millards in handwriting, something has been added in millards by way of amendment. That the suit is not barred by limitation and well within time, that there is no case or suit pending before any court or tribunal or any forum on the same cause of action. Cause of action has arisen during January 2007.
Where from? Just now you are submitting that it should be looked from the plaint. Looked from the plaint. Where is that plaint 2017? Where did you say? When did the June 2017 cause of action, Jan 2017 cause of action?
In the other one, millards, it is reflected.
We are looking at the CRP 1000182.
Please.
So in 100182, you said about something written, the cause of action arose during Jan 2017.
Yes. And this
Just now you're submitting that cause of action alone cannot be looked from the para. We have to look from the plaint. So in the plaint, where is this Jan 2017 incident?
That's
Tomorrow, heard counsel or parted as tomorrow? Yes, please.
Yes, day after tomorrow.
Day after tomorrow.
Personal difficulty tomorrow.
Day after tomorrow, no
Yes,
problem.
bless.
Yes, please.
Still number 40, Karnataka.
And further responding.
Yes.
Husband's petition, my lords. There is also one petition by the son. My lords, I have filed a petition seeking reduction in maintenance amount, my lords.
What, how much is the maintenance granted?
My 10,000 is the maintenance amount, my lords. I have been paying 7,000 per month as ordered by this honorable court while granting order of stay.
7,000 you're paying.
I am paying every month, my lords.
So 10,000 is only to the wife.
No, only to the son. Only to the son.
Wife is not granted.
Wife is not granted.
Your,
And for the wife, for the son, my lords.
so wife is not
Wife
asking
is
for
not
money.
asking.
Well, how much you sought for?
I had sought for 30,000 for the trial court. My lords,
You want enhancement?
Yes.
How much, what is the salary of the father?
My lords, I earn 96,000, my lords, while the wife earns 65,000 she earns. She is the primary school teacher. I have the latest the salary statement.
Well, let's take it there.
Please.
Let's, she earns 65,000, you earn 96,000.
Please. After deductions, somewhere my take-home salary is around 45,000.
What are the deductions? Half of the salary.
My lords, I had availed loan on my PF, I had availed loan on my KGID. Prior to when we were together, I have availed and that is being repaid. I have also taken life insurance premiums. I have my salary statements around 45,000 is my.
No, she has to take care of the child.
Please, my
There
lords,
should be your contribution.
please, my lords.
10,000 is a very,
My lords, my
for
only
the
submission
salary
is
of
that-
yours.
My lord, my only submission is that, my lords, I am ready to take her as of today. I am ready to
Lords,
bear all
we
the
filed
issues.
a divorce petition, my lords.
My lords,
Divorce was dismissed.
it was dismissed, my lords.
Now he is claiming he
No,
wants.
no, the divorce is dismissed, that means you want to join him.
No, I contested, my lords. He is not taking
No,
it.
you contested
Yes,
that you don't want divorce.
Yes, lords, I contested.
Now he says he's ready to take.
My lords, even
My
as
lords,
of
there was cruelty involved, my lords. That's why I
Then
stated.
you want, then they should have.
That
taken
was seen in the judgment, my lords. And he himself has thrown me out. There is no cause that I.
Please understand, it's not about the merits of the matter, the technicalities. He filed for divorce, you contested, what does it mean? You don't want to give divorce. Now he says he wants to take you back.
Yes.
Then there should be some answer to that. Get instructions from your client. Is there any scope for reconciliation, or she wants to join him? Or shall I refer this matter to the mediation, then we will pass orders.
Mediation already happened before the trial court, my lords. Next week it may post seek instruction from him.
List this matter on 12th of December. By the time the council will.
First week of December, my lords. In the second week I have trial listed.
First week is not possible. List it on 17th of December. Then
12th
come-
it is okay. 12th I'll manage.
12th of December, then comes for the respondent shall get instructions whether the wife is ready to join the husband as a counsel for the petitions of the son. The husband is ready to take her back
please.
along with the child. Yes, next.
Number 14, Petition Agreement.
This is petitioner, my lords, husband petition. For simple order is at page
How
number
much is granted?
12,000, my lords.
What is your income?
My lords, I am having 10,000, my lords. I am having laundry business.
What is the evidence adduced before the court? Both of you filed your statement of assets and liabilities.
No, my lords.
Why?
Not filed, my lords.
That counts for the petition submits that the income of the petitioner is 10,000 and the court had granted 12,000. Considering the court has failed to consider the submissions made on behalf of the husband, considering the same, they shall stay or fall for the proceedings on the condition that the petitioner shall deposit an amount of ₹6,000 by 5th of every succeeding month and shall deposit the arrears at 6,000 from the date of petition till today, within 8 weeks from the date of receipt of the copy of the order, default order, any of it. Yes.
Please.
Yes.
Number 42. General Bill.
What's wife's recovery petition has been dismissed. What's holding that the petition is beyond 1 year. In fact, what's
That give the judgment. My order is right. Yes.
what's this aspect what's was considered by the Jharkhand High Court also. What's the section 125 is only a penal provision, and the wife is a it doesn't take away right of the wife to claim maintenance beyond 1 year. And under section 128, lots she can maintain a petition. Lots the trial court ought to have gone taken this aspect of the matter and ought to have ordered under section 128. But on mere technicality, lots the petition has been dismissed.
Please come. The wife is before this court, agreed with the orders passed on criminal miscellaneous number 143 of 147 of 23rd, 23, dated 8th February 2024, whereby the court had dismissed the recovery proceedings initiated by the wife on the ground that the recovery is barred by limitation. The court observes that the petitioner cannot split into two parts, that is one for recovery of time barred maintenance amount for the period from 10/1/2022 to 10/1/2023, along with the recovery of maintenance amount for the period from 10/1/2023 to 7/11/23, which is within limitation, where there has been no petition for recovery of the maintenance amount for the period from 10/1/2022 to 10/1/2023. The court has relied on the order passed by this court, accorded by this court in ILR 2004, Karnataka, not a coordinate, as reported in ILR 2004, Karnataka 5283, that is in case of Dharwad versus Renuka, wherein the court held that for the benefit of persons who need maintenance, it is observed that Section 125 of CRPC is meant for the benefit of persons who need maintenance and requires to be construed accordingly. But as long as the said proviso providing limitation to recover arrears of maintenance is in the statute book, no other view could be taken. It is for the legislature to consider and decide whether said proviso be deleted or amended suitably, so that persons having such an order in their favor, who either on account of ignorance or for some other reason fail to enforce it within 1 year, can enforce it even after 1 year, or to make a provision so that such an order could be enforced within a year of its attaining finality. Relying on the said judgment, the court had dismissed the recovery proceedings initiated by the petitioner from 10/1/2022 to 10/1/2023. Is it so?
Please.
Let counsel for the petitioner had relied on the judgment of
Jharkhand High Court.
Jharkhand High Court, take his structure. Had relied on the judgment of the Jharkhand High Court in case of Balram Hato versus the state of Jharkhand, reported in 2022, latest case law 3808 Jharkhand, dated 20th September 2022.
Where is this? Held that Lord's section 125(3) is primarily a penal provision, and section 128 doesn't bar the wife from claiming maintenance beyond 1 year. May I read it's a small.
It is observed that, to put it in nutshell, for initiating a proceedings for enforcing an order by revoking section 128 of CRPC, there is absolutely no provision providing for limitation as it is provided in respect of proceedings under 125(3) or CRPC. Though it is filed beyond 1 year, the court was right in entertaining the same, relying on the said judgment. When counsel submits that, the court went wrong in dismissing the petition. Though notice is served on the respondent, no acknowledgement is filed on their behalf. Next para. Having heard the then counsel for the petitioner, there is a material not record. The only issue that falls for consideration before this court is whether the petitioner herein can recover the maintenance and can maintain the recovery proceedings beyond the limitation, beyond the period of 1 year. This aspect, this court in Sri R.S. Ganesh and Kumari Madhumita and others, arising out of writ petition number 10449 of 2022, dated 27 June 2024, has dealt with the said issue, and this court had considered the judgment of the Honorable Appeals Court in Shahada Khatun and others versus Amzad Ali and others, wherein the Honorable Appeals Court, that is 1999, 5 SCC 672. The court observed that the application filed by the appellants therein under section 125(3) of CRPC, which is beyond 12 months, was in continuation of the earlier applications and for subsequent periods of default on the part of the husband. So the provision to section 125(3) do not extinguish or limit the entitlement of the party therein to the maintenance granted by the trial court. And the apex court has set aside the order of the High Court, and the directions were issued to the respondents therein to pay the entire arrears of maintenance due to the appellant therein from the date of filing of the maintenance petition within a period of 6 months, and current maintenance commencing from the month of September 2013, payable on or before 7th October 2013, and thereafter to continue to pay monthly maintenance on or before 7th of each successive months. And the court has also, apex court has also observed that in case the said order is not complied with, the trial court was directed to issue warrant of arrest and to ensure that the same is executed and the respondent be taken into custody and to suffer imprisonment as provided under section 125(3) of the CRPC. In view of the law laid down by the apex court, a petition that is filed seeking recovery of the maintenance beyond 1 year is maintainable, and the order reviewed is liable to be rejected. Accordingly, the order is set aside, and the trial court shall consider the application filed by the petitioner in accordance with law. Accordingly, the matter is allowed and remanded. Just next.
Seal number 43, 44, and seal number 45.
But you don't want to take a copy of it. In that, that is, Supreme Court judgment extract is there. As it is to extract, that it is to take a copy of it. Yes, next.
And the petitioner is
45, yes.
the husband petitioner.
How much is granted?
7,500 to the wife and 15,000 to the daughter-in-law.
In this case,
That is altogether 23,000
22,500.
or 22,500.
Yes, and getting salary up to 77,000. A specific attention, before the trial court, the present petitioner has proved that the wife is working in a Jilla Panchayat.
How much she is earning?
She is getting salary up to 22,000 and all. It is observed by the trial court in file number 25 at page number 28. So proceeded to pass the maintenance in respect of the wife.
So we'll continue that 15,000 as far as the son is concerned, if that's the case.
Even the daughter is only 4 years daughter. 15,000 is also exorbitant because already I have made some arrangement to be my daughter.
Like,
Investing in mutual funds and some deposits to her future.
no, but she requires monthly maintenance. She must be 4 years means she must be going to school. She must be
Required
going.
any education expenses at the time of her education and ready to pay. I'm not.
No, she has joined. She must have
Even though
4
I have
years
filed
means
in-
she must have joined the school.
Even though I have filed in petition.
Then we'll record like this. Entire education expenses shall be borne by you.
And my submission, even I have filed a petition for the NC petition, wherein both have agreed that we are eligible to join. On that basis, the NC petition has been dismissed. Those is not come forward. Therefore, I challenge this court by filing an appeal. If this court has passed any order, if you come before this court under, we will settle the matter in one time.
Then we'll only issue notice.
Respect of wife may pass some orders. Our daughters, there is no issue. I will
So
give
we'll
you
say,
15,000.
we'll say 15,000 is granted to the daughter,
Yes.
7,500 to the wife. How much is the amount? 6,000?
7,500 to the wife,
That we will-
15,000 to the daughter.
So that's what order I am saying, yes. As far as the wife's amount is concerned, we'll stay.
Yes.
As far as the daughter is concerned, we continue to pay.
Please.
Then counts for the petitioner submits that the trial court has awarded an amount of rupees 15,000 to the daughter and 7,500 to the wife. He submits that the wife is working in a Panchayat,
Jilla Panchayat.
Jilla Parishad department and earning a salary of 22,000. He submits that all these aspects are not considered by the court. In fact, before the court in a MC proceedings, it is submitted that both the parties want to reside together and later the wife had failed to join the husband. Considering the submissions, they shall be stay of all further proceedings pursuant to the order dated so and so on the condition that petitioner shall continue to deposit an amount of rupees 15,000 that is awarded in respect of the daughter.
Please.
And if there are, and it shall continue to pay 15,000 by 5th of every succeeding month. And if there are any, arrears,
If I comes, I will deposit the arrears before this court.
if there are arrears, and the arrears shall be deposited within a period of 8 weeks from the date of this 4 weeks.
Yes.
Within a period of 4 weeks from the date of receipt of the copy of the order. Notice, emergent notice to the respondent.
Please.
Yes, next.
Number 46. Sir Balka.
Yes.
Please, ma'am.
File the translated copy.
Yes, ma'am. I have filed my.
Very sad. Why is it that it's coming up for the first time? Where is the proceedings? Shall place before this court the translated copy of the IA affidavit filed before the trial court. What is this? You are the defendant in the suit.
Please, ma'am.
What is the suit for?
Suit is one for where injunction filed by the plaintiff. But in the prayer column, they have also sought for declaration that they are in lawful possession of the property. And if we read between the lines of the plaintiff, meaningful reading, not a formal reading, it will not disclose the clear right to sue to the plaintiff. And in fact, my lord,
We'll see the plaint first.
statement. The subject matter of the suit property involved in this case is 10/7, measuring 3 acres 37 acres. In respect of which, way back in the year 1982, there was a partition as per ME number 544, my lord. And both the plaintiff and defendants are in joint possession of the property. But now the plaintiff suppressing all those facts have filed this suit and not produce the record of facts. Section 132 of the Karnataka Land Ordinance deals with if they have not produced the record of rights, the plaintiff is also liable to be rejected. They are required to place all the cards before the court. Suppression of material fact amounts to fraud. Any of the rulings reported in VIR 1994
We'll
Supreme Court.
read the plaint first.
Please, madam, please.
According to you, what is wrong with this plaint?
The wrong is, my lord, both plaintiff and defendant may I invite our last time attention to the translated copy, page number 17, where in mediation 1244 is certified, Absat Varni. Both together, plaintiff and defendants, their existence are filed worthy, containing inter-alia that they affected partition in this.
No, we cannot look into all that. We have to look at the plaint.
Yes, sir.
Looking at the plaint, please tell the court why it has to be rejected.
It has to be rejected, my lord. First of all, it has been filed after lapse of nearly 42 years now. 42 years.
It's a question of limitation.
Question of limitation added to it the cause of action also, my lord, because since from 1980 to 83, both are in a joint position. Both are cultivating the land.
How will the court know all that?
Yes,
How will the court know
Yes.
about what the facts you are stating from the plaint? Those are all the facts you are stating in the written statement.
Yes,
And
sir.
now, only looking at the plaint, how the court will say that it is barred by any of or any, it falls under Order 7 Rule 11.
Yes, madam. May I invite your last
I am at the plaint. Please come to the plaint and tell the court.
Yes, madam. They say that they are having half portion. At least prima facie to show that they are in a lawful position to the extent of half. They have to have produced record of rights, suppressing the material fact, and they have also sought for declaration in the prayer column. First, they have sought for injunction, and subsequently in the prayer column, they have also sought for declaration. If they want to seek for declaration, they have to produce the title deed, say deed. It is a case where it is a joint family property way back in the year 1982. They have effected a partition. That's
Now,
all.
please come to the plaint order.
There is no clear way to sue. It is we put in the bud, that is what our lordship justice V.R. Krishna has said way back in the year 1977. I also have a good number of decisions on
Yes,
this
yes.
point.
We'll read from the order. Where is that? What did the court say?
Yes, sir. Please, madam. Para number 2. In the accompanying affidavit of the interim application, defendant number 1 has awarded that there is no cause of action to file this suit. The insistence of the defendants have been using and enjoying over the suit's property since 1981-82. As per NU number 1244, there was a partition in between the plaintiff and defendants since 1981-82. The names of defendants were entered in column number 9 and the possessor in column of the record of rights in the suit property. The suit of the plaintiff is barred by 42 years law of limitation, hence failed to reject the claim. And third contrast, the counsel for the plaintiff has filed objection to the IA, wherein it is contended that the application filed by the defendant is not material either under law or on fact. Recently, the
Where is your IA? IA seeking that Order 7 Rule 11 affidavit?
Yes, ma'am. The translated copy is page number, my lord. Page number 9, my lord. That is the higher one filed by me, my lord. Under Order 7 Rule 11A and D of CPC.
There is
Page number 10, my lord. 9 and 10, my lord. That the plaintiffs have no cause of action to file the appeal proof against the defendants, since the defendants have been acquired half share of the suit land in the suit schedule property, with the mutual consent of the plaintiff and the plaintiff's family since the time of their father and in the year 1981-82, when the plaintiffs were partitioning the shares. It has been agreed that the defendants are having half share in the suit schedule property, and worthy has been given and by virtue of the said verdict, mutation is certified by the revenue minister finally as per any number 1244 of the August list. Before the certifying the mutation, the respondent number 1 has issued notice to the interested parties. Thereafter, the RI has certified the said mutation dated 12/3/1982 without raising any dispute. Almost 42 years have been passed. The said ME number 1244 was approved and no one has questioned till today. While also be entered in column number 8 and column number 12 of the required text. Even presently also, till date, the names of this plaintiff and defendant is got entered in column number 9 as a owners and in cultivators column as a cultivator. Both are in a class 1, equal and class position of half of share manner. The said defendants are also having half owners of the said suit property. It is known to the plaintiff because they have served with the notice and they have not filed any objection. They have not filed any question. The certification of mutation entry 1244. That entry is still intact. It is a quasi-judicial authority who has conducted the inquiry and certified the mutation entry, and that mutation entry is intact. So long as that mutation entry is set aside by a court known to law, because they are also party, they have signed it, and any statement made.
This is not this case which fall under the order 7 to 11, please come.
Please not, because the injunction suit is also not maintainable against the truth.
That all those maintainabilities will be decided by the court, not in a petition.
There is no clear right to sue. At least they would have filed, stated all these facts. They have suppressed the material fact. Therefore, it is
how will you say in order 7 to 11 that they have suppressed the material facts because the court will not look at your statement while deciding that application?
1244 mutation entry is there.
That will be decided, not a case for order 7 to 11. Agreed with the orders passed and.
At least let them appear, my lord. How they are going to substantiate this? They are going to find false and frivolous suit. Thereby courts have been overburdened by such ultimately they will be dismissed.
I number 1.
At the far end of the trial, my lord.
Invoice number 150 of 2022 dated 1st October 2024. The defendant is before this court. The respondent herein has filed a suit seeking declaration that
is not. Limitation is also there, my lord. After you have filed within 3 years, Article 58, my lord.
Stating that the plaintiffs are in lawful possession and enjoyment, to declare that the plaintiffs are in lawful possession and enjoyment of the suit property and consequential relief of permanent injunction against the defendants, their agents, servants, or anybody claiming to them, be restrained from causing any kind of obstruction in respect of the suit scheduled property. The case of the plaintiff is that the proposers of the suit land died on 19/3/1946. Leaving behind his wife by name Tippava and sons and 4 sons, and their names are entered into the revenue records. And they are cultivating the lands, and they have been in possession of the property. After the death of Tippava, the sons have entered their name in the revenue records. One of the son died recently on 5/4/2000. One of the son died on 5/4/2003, leaving behind his villas. The daughters have relinquished their shares by receiving gold and other articles at the time of the marriage. Another son died on 1/12/2019, leaving behind his wife and the daughters and 4 children. And even in his case also, the daughters have relinquished their share to the sons by receiving gold and others at the time of their marriage. It is a case that the plaintiffs are the absolute owners and cultivating the land. Defendants have no manner of right and title. It is stated that the defendants' names are entered half in the record of rights in column number 11 illegally. The defendants have taken undue advantage of this and harassing the plaintiffs from cultivating the land. Hence, they have come up with this suit. According to them, the cause of action arose on 17/8/2022 when the defendants tried to obstruct by taking undue advantage of their names in the revenue records. The defendants have filed the application under Order 7/11 seeking rejection of the plaint. It is a case of the defendants that the plaintiffs have no cause of action to file the suit. The defendants have acquired half share of the land in the suit property with the mutual consent of the plaintiff and the plaintiff's family since the time of their father in the year 1981 to 82, when the plaintiffs were partitioning the shares. And it is agreed that the defendants are having half share in the suit land. And what he has been given, and by virtue of the said work mutation, is certified by the revenue authorities. And before certifying the mutation, notice was issued to the interested parties. The mutation was dated 12/3/1982. After 42 years, they have come up with the suit. It is the case of the defendant that the plaintiffs have suppressed the true facts and filed the suit with the sole object of causing unnecessary inconvenience and harassment to the defendants. According to them, there is no cause of action. Suit is barred by limitation, and accordingly, it has to be rejected. The trial court, by order reviewed, had dismissed the IA While discussing the IA, the court has observed that while considering the application under Order 7/11 CTJ, is not required to take into consideration the defense set up by the defendants in the written statement or other documents. The question whether the plaint discloses any cause of action and whether it is barred by any law is to be decided by looking at the elements contained in the plaint itself and not the defense set up in the written statement. The plaintiff's case is that on 17/8/2022, the defendants tried to interfere and obstruct the position of the plaintiffs, and the said amendment is sufficient that the plaintiff has shown the sufficient cause of action. The contentions raised with regard to the limitation has to be decided on merits, and all the defense that is taken by the defendants has to be adjudicated at the time of trial by framing issues and adducing evidence. Hence, the court do not find any reasons to entertain the application filed under Order 7 or Rule 11, Order 7 Rule 11. Next para. Then counsel appearing for the petitioner submits that the suit is barred by limitation. The suit is filed after 42 years from the date of the mutation of the property in favor of the defendants. It is stated that they have come before the court with suppression of material facts. There is no cause of action for them to file the suit. When the application is filed by the plaintiff seeking rejection of the plaint, the court ought to have considered all these aspects and ought to have rejected the plaint he submits that these kind of frivolous litigations they have to be nipped at the bud, and he's full stop. He submits that by entertaining this plea, the defendants are put to lot of hardship, and the plaintiffs have created unnecessary litigation. Next paragraph. Having heard the lead counsel for the petitioner, there is a material on record. The plaintiff asserting his right to the property and making allegations that the defendant is interfering with his peaceful possession and enjoyment of the property, being the owner, has filed the suit. Defendant's case is that the property is partitioned long, but the property the defendant is enjoying for the last 42 years. Now they cannot come up with this suit, come up with the present suit. What is the partition that they take? What is how the property is allotted to the defendants? From when the defendants are in possession of the property? What are the revenue proceeds? What are the entries made in favor of the defendants? Whether the suit is barred by limitation or not. These are all the questions of a fact and law, which has to be decided by the court after the necessary evidence is adduced by both the parties. At the threshold, when the court is looking, or when the court has to decide an application under Order 7 through 11, court can alone look at the plaintiff amendments. The trial court had rightly observed that looking at the plaintiff amendments, they make out a cause of action, and it do not disclose that it is barred by any law. In that view of the matter, this court finds no reasons to interfere. Accordingly dismissed.
On succession, while disclosing of the main suit, the observation made is
Same that any of the observations made by this court while disposing of this application shall not be construed as an expression of this court, and the trial court shall consider the suit in accordance with law.
Number 47, is it the petty?
Yes. How much is the amount granted?
8,000.
What is your income?
The age of the petitioner is 70 years.
Huh?
70 years the age of the petitioner.
70 years.
Yes, ma'am.
What is the wife say?
Okay.
That counts for the half 50%.
Initially, she was private maintenance in the year 2008. For permanent alimony, he has given the house property.
He has given. It's recorded by the court. It's recorded.
Yes, ma'am.
No, I'm saying that permanent alimony is the divorce proceedings.
In 2008 only, he has given the house property for the wife.
Is it in a where it's an arrangement between the parties?
Court.
Where is that? The respondent has not produced any document to show that he has given house worth rupees to the petitioner. You are receiving how much pension? Huh? 26,430. And what is that? What the maintenance is given is?
8,000.
Why you can't pay?
He's at the age of 70 years.
You don't have to work, you're getting money. The council of petition submits that the petition is aged 7 years, and the court had granted maintenance of an amount of rupees 8,000. He submits that in fact he had transferred the house worth rupees 70 lakhs to the wife, while as a permanent alimony. The court had tried to consider all these issues considering the submission of the learned counsel, there is a stay of all further proceedings on the condition that he shall continue to pay an amount of rupees 5,000 the 5th of every succeeding month and shall deposit the arrears at so and so at the same amount within 8 weeks. Default order. Yes, next. In all these cases, on such deposit, they are liberty to withdraw. Yes.
Number 48.
Yes, I'm petition. Petition is filed by the 520, 15. Petition is filed by the.
What? How much is granted?
Petition is dismissed because no one can.
This is filed with the wife.
Please.
Notice to respondents.
Issue notice.
Yes, next.
Number 49.
Yes.
Petition is done 2 years small baby.
Seeking transfer from where to where?
From Bailam to Garat,
What is the distance?
130 kilometers.
130 kilometers.
Please.
Any other cases pending there?
Yes, one case is pending.
In your place?
In that, yes, please.
Yes, madam. My submission is that this matter has been settled before the trial court now. Because I have filed a conjugal right. I am ready to accept her without any conditions now.
Then what is this MC you seeking transfer?
Only that instigation of the father of the petitioner that
No. You say that the matter is settled. Then what is the transfer she is seeking?
only for maintenance, my lords.
Criminal miscellaneous you are seeking transfer of?
No. Restitution conjugal rights, which is filed by the respondent in Bailam. That case has to be transferred to Garat.
He says that that matter is settled.
No,
No settlement,
No.
but she had not agreed that.
No, it is not settled.
If she is not agreed, how it amounts to almost settled?
Please.
During the mediation, she is ready to join the company of the respondents, my lord.
Is it
Your
true?
lordship, no, she is not attending the Bailam court. It is false submission before the honorable court.
Yes, please come.
Please.
The present petition is filed seeking transfer of FC number 33 of 2024, pending on the file of the senior civil judge Balihongar to Gadak, the Gadak family court. The facts of the case are: the marriage is organized on 28 to 2019 at Balihongar. Because of the disputes between the parties, the petitioner wife is staying at the matrimonial home. The wife had filed a petition at for the current family court seeking maintenance under section 125 CRPC. Thereafter, on 28/3/2024, the husband had filed a petition under section 9 of the Hindu Marriage Act on the file of the senior civil judge Balihongar, that is MC number 33 of 2024. Now the present petition is filed by the wife seeking transfer of the said petition under section 9 of the Hindu Marriage Act from Balihongar to Gadak. It is submitted that the distance between both the places is about 130 kilometers. She is having a small daughter to take care of, who is 2 years old. Further, already the criminal miscellaneous is pending on the file of the family court, Gadak. And as such, considering the inconvenience caused to the wife, the matter may be transferred to the pending MC may be transferred to Gadak. Land counsel appearing for the respondent husband submits that. In fact, in MC, the wife had agreed to join the husband. The same is denied by the land counsel for the petitioner wife. It is submitted that land counsel for the petitioner's respondent submits that no grounds are made out seeking transfer of the petition from Balihongar to Gadak. Next one. Having other counsels on either side, produce a material on record. The undisputed facts are MC number, the criminal miscellaneous is pending on the file of the family court at Gadak. Further, the wife is having a daughter who is aged 2 years, and the 2 years considering all these facts and the inconvenience being caused to the wife, this court deems it appropriate to pass the following order. Accordingly, so and so is withdrawn and transferred to so and so. Yes, petitions allowed?
Your Lordship, please kindly mention on date to attend. Date of specific date and month.
Court will give.
Yes, month of it.
Yes.
Seal number 50, page number 30.
As well as to the, I filed a memo regarding the, regarding the, as well as to the respondent.
Use the mic, I'm not able to hear you.
I filed a memo regarding acknowledgement of served the handsome to the respondent. my lord.
It's already shows served.
Sir.
Yes.
Postal track.
Seeking transfer from Kalburgi to the Sandur. The distance is.
How much is the distance?
350 kilometers.
Any matter pending here?
Yes, in Sandur, the maintainability is filed by the petitioner.
Maintenance petition is pending. Maintenance petition
Yes,
is
yes,
pending.
yes,
Children?
One child is 6 years of age. He is surveying mother.
Yes, please. The present petition is filed. Seeking transfer of MC number 3 of 2024, pending on the file of the family court Kalburgi to the senior civil judge and JMSC, currently sitting at Sandur. The facts of the case are the marriage was organized on 1/5/2016. And in view of the ill treatment, on marriage was organized on 1/5/2016 after the wife was conceived in view of the arrangement by the husband. It is a case of she had to leave the matrimonial home on 20/10/2016. On 25/3/2017, she gave birth to a baby girl. And the parents of the petitioner, they have made their best effort to reconcile the matter. The husband had filed MC number 3 of 2024 on the file of the family court at Kalburgi on 3/1/2024. The wife on 12/3/2024 has filed a petition for maintenance in criminal miscellaneous number 396 of 2024 before the JMFC court, civil judge and JMFC court, Sandur. It is submitted that the wife, the land comes for the petitioner submits that the wife is facing difficulty to travel to Kalburgi, which is 350 kilometers. Further, she has to take care of the take care of the child who is 6 years old, and further, the other matter is pending at so and so. The same, the Sandur, so next one. No notice is no representation on behalf of the respondent. Considering having heard the counsel for the petitioner, peruse the material on the court. Considering the fact that already a petition for maintenance is pending on so and so, and the distance between both the places is about 350 kilometers. And further, the wife has to take care of the child. Considering all these aspects, this court is passing the following order. The so and so pending on the file of so and so is withdrawn and transferred to so and so. Accordingly allowed. Yes.
One petition.
Duly respondent number 1.
8,000 is granted to wife
8,000.
and 6,000 to children, 3,000 plus.
8,000 to the wife.
Yes.
8,000 to the wife.
And 6,000 to two children, 3,000 plus 3,000.
So put together 14,000 is granted.
Wherein that she is working and in Belgaum.
What is she?
She is an MBA graduate.
How much she is earning according to you?
According to me, my lord, she is earning 50,000.
50.
Yes.
You are earning how much?
Earlier occasion, my lord, I was working at different states, wherein wife was along with me. Thereafter, my lord.
No, what is your income?
At present, I have no income, my lord. Since, my lord, I joined the company rate of
At that point of time, earlier, what was
earlier
your?
I was getting 30,000, 25 to 30,000 at a different places.
Let's see the order. Both of you have filed your statement of assets and liabilities?
Yes,
No, but the court, the respondent has contended the petition number 1 is working.
I.
No acceptable evidence is produced.
Yes, ma'am. I find a statement stating that, madam, in respect of 10,000, I made a message along with myself and my mother. I made a food related to 10,000. And miscellaneous 10,000 rupees for food and other things, ma'am. And 5,000 for other, 15,000 I mentioned. Court comes to the conclusion that, madam, when he states that he has no salary, and he in his statement he makes that he will 10,000 and 15,000.
Did the wife state about her income?
She states that, madam, she has no income, she is not working. However, madam, under section 91, application was filed to someone with the document where she is working. However, the employer has given a document that she is not an employee of the company. Surprisingly, that, madam, that company belongs to a relative.
So whatever the material that on record shows that she is not having any income.
Yes, ma'am. However, she produced a bank statement wherein a certain salary is deposited to her account.
Every month.
Not it is irregular. Court of the opinion that those salaries are irregular. So based on that,
So now you tell the court what are the grounds to interfere now?
Now, my lord, he is only son to the mother. She is ailing mother and deciding at Dharwad. Wherein, my lord, she is asking him to join him at Dharwad.
Not on that. We'll not go
That
into
is the
all
only
the
problem, madam.
aspects. Now she is seeking maintenance for the son and for herself and the child. Court had granted 8,000 and 6,000. So what is your responsibility towards the child and the wife?
I am entitled to maintain the children. However, she is also working, but I am not able to produce anything that she is getting income. However, that is the only occasion.
Then how are you spending that 15,000? Where from you are getting?
Here, I saved something.
How much you are saving?
Exact amount is not mentioned in the statement. However, my mother is also getting some pension. But out of which,
so you don't have to maintain her.
I don't have to maintain it. But I am looking after my mother.
No, that is a different aspect.
Yes.
Looking after is a different aspect.
And occasionally I get it. Some jobs, things, and mechanical engineer.
We'll see. If you want, if you come out, what is that you are ready to pay? We'll think about, or else you file your bank statement before the court. Then transfer the petition shall place before this court the bank statement for the last update from the last 3 years. This is matter on 17th of December.
Yes. Number 15.
Petitioner here is challenging the order passed in criminal miscellaneous 1 of 20.
Where is the other counsel? Counsel the respondent not present. Petitioner is present. This is matter tomorrow. As part heard. Yes, next.
Number 15. 53.
Yes.
Inspection.
How much is the maintenance grant?
4,000 has been granted to the trial court. At the first instance itself, the matter was.
What is your income?
As per Eviction C, per day, I earn 419 rupees. I am the data entry operator that is the district hospital. Based on the present day itself, I will be daily basis.
You are getting 12,000 per month.
On an average, 10 to 12,000.
10,000.
Yes.
Court is granted 4,000.
4,000. And I made an allegation that because of the desertion of the life these are all I filed a divorce petition before the same court. It has been considered where there is a litigation cost has also been levied.
With order notice in this, no interim order, 4,000, what will the court say? Notice to the respondent. A petition is permitted to take out hand summons on the counsel, appearing to the respondent before the trial court. Shall file a memo to the defendant.
3,000.
On 3,000 state. They shall be then counsel petition submits that wife is earning.
No, she is not.
So then how will she live?
There's a reason that.
Then counsel the petition submits that the court has failed to consider financial capacity of the husband and granted an amount of rupees 4,000 as maintenance and is working on a daily wage basis. Considering the same, they shall stay of all further proceedings. On the condition that petition shall continue to pay 3,000 and 3,000 by 5th of every succeeding month. Same arrears also, say, within 8 weeks, or else the default order. Yes, next.
Order by seal number 54, Santosh Kumar, disseminate.
Petition.
Yes.
Relief notes under section 6 of law specifically that for possession. Petitioner is in possession of notes 2 acres of land in survey number 213, which belongs to notes the Forest Department since 1978. In the year 1995, notes 120 Manjappa Naik and others, they have dispossessed me from notes the 2 acres of land which is in my possession. So, suit is filed in section 6 of notes specifically that in OS 66 of 1995 by giving notes the complete boundaries of notes the subject property.
When is the suit? When is the decree?
Your suit is the earlier suit is note 66 of 1995. The decree is on 19/4/2001. It's, I have filed for execution petition 2022, which has been closed on 28/7/2004.
Closed means?
Opposition has handed over through the court.
Then
On 8/4/2005, the present respondents dispossessed me. And I have issued a legal notice on 22/5/2005. Which was served on them on 27/5/2005.
notice is when?
22/5/2005. And the suit is filed on 13/6/2005. 13/6/2005.
Why it is dismissed now?
At the first instance, the suit is decreed, considering the decree passed earlier. Considering the boundaries and the decree passed in the earlier suit.
What section 6 of the specific relief act says?
Subsequently, what has happened is, the portion which is in my possession, that has been subdivided, and the property is identified as survey number 213/A. Earlier, in the earlier suit, there was no subject.
Let us look at the impugned order first. Please come to the impugned order.
There are 15 of the appellate court orders.
No, the impugned order. Impugned order.
Please.
Where is it?
Impugned judgment is page 12.
Let's
Page
read.
12.
From the reasoning part, please read.
There are 15, page 30.
What are the issues that are framed?
Issues are at page number.
Whether the plaintiff proves that he is a peaceful portion enjoyment of the property.
Please.
Disposes the plaintiff from the suit property. Please come.
The court says that the earlier suit was with respect to survey number 230, which actually measuring 56 acres in all, out of which I was in possession of 2 acres. Subsequently, it is subdivided, and the 2 acres of land has been given a new number 213/A. Now the court says the earlier decree is with respect to 213.
Where did you say with regard to all this?
But there are 15.
15 of the?
Of the trial court system. Page 30. The suit property is entirely different from the property claimed by the
No, it is not about what did the court say. What did you say in your suit?
Please.
What are your amendments in that? With regard to this this change of the survey number and all.
Specifically, while not describing the boundaries of the suit property, I have made it clear I have specifically mentioned that this 213A is part of 213. Lordship, may kindly see, my lords, my great my lords.
So, have you filed any documents before the court to show that there was subdivision? This particular survey number is now new survey number so and so.
No, there is no document. But my lords, the boundaries found, my lords, in the earlier suit and in execution and in the present suit are one and the same.
Let's look at the file.
There are 15.
Yes.
The suit property is entirely different from the property claimed by the plaintiff.
Not para 15.
Page 13.
From 14, let us see. I have perused.
Please. I have produced exhibit P1 to P4. P1 RTC belongs to survey number 213A, situated at Adelaide. The plaintiff has shown the suit schedule property as survey number 230. The plaintiff has also stated in the claim that survey number 30 is now demarcated as 230A. Even exhibit P2, certified copy of the decree, and exhibit P3 is kabja receipt, belongs to survey number 230. It is pertinent to note that the plaintiff is claiming the position on the basis of the decree passed in OS number so. I have produced the decree. The decree has been passed in respect of survey number 213, but not in respect of 213A and 3 will be dilapidated buildings. The decree has been silent about 213A and 3 principal dilapidated buildings. The subject matter of the suit is survey number 213. Further, it is pertinent to note that even according to kabja receipt, that is possession certificate, the position of 213 has been given to the plaintiff, but not in respect of survey number 213A and 3 principal dilapidated buildings. Even according to exhibit P4 complaint, the plaintiff has filed complaint against the defendants in respect of survey number 213.
Further, it is pertinent to note that the plaintiff has not produced single document to show survey number 213 and 213A are one and the same.
Please.
Then what do you expect the court to do?
Well, it's the boundaries article because Lords have specifically stated that this portion of 2 acres of land, which is in
no burden on yourself.
It is burden is there. Even Lords in the claim, I have made it specifically clear that Lords this portion, because Lords it is a vast land.
Particularly in the light of the fact you are seeking, you have filed this suit basing on a judgment and decree in the earlier suit.
Please.
And when you say that the boundaries are the survey numbers are changed, unless and until that is there before the court.
The entire survey number is not changed.
Whatever says A,
subdivided. Even the court says that the plaintiff has also stated in the plaint that survey number 230 is now demarcated at 230A.
The forester so and so has given information that the plaintiff has not encroached any portion in survey number 213, 213A, so and so. Are entirely different survey numbers.
Court says the earlier suit is only with respect to 213.
No, it is such a simple issue to be decided. Whether there is any subdivision or not is the only issue. What was the property as per the decree is a very simple issue. Why the court has not done any exercise?
My submission, my lord, is admittedly the suit property belongs to the government. It's a forest land. He claims to be an encroacher. The plaintiff claims to be an encroacher. And it is his case that we have dispossessed him and we have encroached his encroached land. That was his case. But issue number 1 and 2, my lord, is answered against it. Issue number 1, my lord, is...
So the whole basis for that is about this, this resurvey, subdivision of the land.
That is one aspect. And second aspect is which Lordship just now read. Exhibit D14 was produced by defendants, which is the report submitted by the forester. He contends that plaintiff never encroached this survey either 213, 213A or 213.
How can he say so? Because 213 is already, a decree is there in his favor.
That was there.
He cannot, no, the forest officer cannot afford to say when there is a decree by a competent court. No, the issue is very simple. Now, whether there is a subdivision in the 213 is not, the 203 is the only issue to be determined. We'll set aside this order and we'll ask the court to decide that.
Madam, I just request your Lordship for a while to go to page 31.
31? Yes.
Paper book page number 31. Internal page is 20. Judgment internal page is 20. Somewhere from here, when judgment is cited, 2012 Supreme Court. I'll just read from that. I have perused the citation in which it is held that under section 6 of the specifically patent, the person files a suit for possession other than the title holder. He has to give all the particulars, that is, who is or are the owners of the property, title of the property, who is in possession of the title of documents, identity of the claimant to possession, the date of entry into possession, how he came into possession, who are the persons in possession, living with him in what capacity. I have perused the plaint. The plaint has not given any details regarding the title of the property, who is in possession of the title of the documents, the date of the entry into possession, how he came into possession. The date, there is no pleadings in this regard. The citation given by the Dharwad Council for the defendants is actually applicable to the facts of the case on. Like the decision of the apex court, the trial court says the details are not there.
Let him will give an opportunity.
Okay.
When set aside this order, please come.
If there be permission with both the parties to, if required, to amend the pleadings and lead evidence.
Agreed with the orders passed in OS number 47 of 2005, dated 24th March 2018. The plaintiff is before this court. The plaintiff has originally filed OS number 66 of 1995 on the file of the civil judge, on the file of the court of civil judge Barkal, and the said suit came to be decreed on 19/4/2001. Have you filed that also? What is the suit for?
Suit for possession, same
He has filed a suit for possession that came to be decreed. Thereafter, he has filed execution number 20 of 2002, seeking delivery of and the actual possession of the property. And it was delivered on 28/7/2004. And the plaintiff acknowledged the delivery and the receipt passed by him to the court. According to the plaintiff, ever since he has been in actual possession and enjoyment of the property. It's a case of the plaintiff that on 8/4/2005, when he went to the scheduled property to get certain works done, the neighbors informed the plaintiff that the defendants had trespassed into the land and taken unlawful possession of the property and the buildings after breaking open the locks put by the plaintiff to the doors of the building. The plaintiff came to the spot and found the defendants occupying the property. Then he has issued the registered notice to the defendant on 22/5/2005. It was served on the defendants on 27/5/2005 and 2/6/2005. And the defendants refused to receive the notices. Thereafter, he has come up with the present suit seeking possession. As per the judgment and decree passed by the court on 19/4/2001, the suit scheduled property is in survey number
213.
213. Now it is the case of the plaintiff that there was a subdivision. Now it is survey number 213A that falls under survey number 213A. The trial court, by judgment impugned, dated 24th March 2018, had dismissed the suit on the ground that plaintiff has not produced single document to show that survey number 213 and 213A are one and the same. And on the contrary, the defendants have produced exhibit D14 and D14. D14 is the information given to the forest department. And as per that information, plaintiff has not encroached any portion in survey number 213, 213A and 213B. The court comes to the conclusion that on a careful scrutiny of exhibit D14, it appears that survey number 213, 213A and 213B are entirely different survey numbers. The court also observes that the burden lies upon the plaintiff to prove their possession. Then in that case, the burden will shift to the defendant. The plaintiff has to stand on his legs and not on the legs of the defendant. Further, the court observes that under section 6 of the Specific Relief Act, if the person files a suit for possession other than title holder, he has to give all the particulars: who are the owners of the property, title of the property, who is in possession of the title documents, identity of the claimant to possession, the date of entry into the possession, how he came into possession, who are the persons in possession living with him, in what capacity. The court has observed that plaintiff has not given any of these particulars. And as the plaintiff had not failed to disclose all these facts, the issues were held against the plaintiff. And finally, the suit came to be dismissed. That the plaintiff has not proved the factum of prior possession and dispossession. Then counsel appearing for the petitioner, plaintiff submits that the court had failed to consider the scope of a petition that's filed under section 6 of the Specific Relief Act. He submits that a competent court has decreed the suit and also possession was given to him only on the technical grounds that the petition has not stated all the details under section 6, and that no material is placed to show that there was subdivision of the property, had dismissed the petition. He submits that this would cause a lot of hardship to this will cause a lot of hardship to the plaintiff who has been put in possession of the property by virtue of a judgment and decree passed by the court. Next paragraph. Then counsel appearing for the respondent defendant submits that the forest officer has given a report stating that either 213 or 213A or 213B, there is no encroachment by the plaintiff, and also he has failed to give further details. And considering the scope of a suit filed under section 6 of the Specific Relief Act, court has rightly dismissed the suit and no grounds are made out seeking interference with a well-considered judgment passed by the trial court. Next part. Having heard the counsel for the petitioner, having heard the counsel on either side, for instance, material on record, the suit is filed seeking recovery of possession as per section 6 of the Specific Relief Act. The undisputed facts are that a judgment and decree is passed by the court by the civil judge, Junior Division Batkal, in OS number 66 of 1995 by judgment and decree dated 19/4/2001. And when the EP proceedings are initiated by the defendant plaintiff, possession he has been put in possession of the property on 28/7/2004. It is a grievance of the plaintiff that in the year 2005 he was dispossessed by the defendants. And he has also, it is his case that there is a subdivision subsequent to the judgment and decree of the court, and now this property is subdivided into 213A. The court has considered the certificate issued by the forest officer, wherein he says that the defendant, the plaintiff, has not encroached either 213, 213A or 213B. The said certificate given by the forest officer cannot be taken into consideration in the light of the fact that there is a judgment and decree by a competent court whereby the possession of the plaintiff is recognized, and by virtue of the execution as per the execution proceedings, possession was delivered to him. As rightly observed by the trial court, when he files an application seeking recovery of possession, the factum of possession, from when he is in possession, how he is dispossessed, and with regard to the fact that there is a resurvey, the subdivision was done, how it is done, and by what proceedings the subdivision had taken place, all these aspects have to be placed before the court. In this case, the defendant had failed to place these documents before the court, and as rightly observed by the court, he had also failed to plead the relevant facts. However, considering the fact that in the light of the judgment and decree passed by the court on in OS number 66 of 1995 and the decree dated 19/4/2001, and further the possession that is given on 28/7/2004, this court deems it appropriate to give a chance to the plaintiff to place the relevant facts before the court. In that view of the matter, this court is passing the following order. The judgment and decree dated so-and-so, passed in so-and-so, is set aside. Both the plaintiff and the defendant are at liberty to adduce evidence by amending their pleadings, if any. If any pleading, the pleadings have to be raised within 2 months from the date of receipt of the copy of the order. Thereafter, the court shall hear the parties and pass appropriate orders within 6 months from thereon, accordingly disposed of. And accordingly, the matter is remanded, set aside and remanded. Yes.
Kindly pass over to that.
Why every day you are asking for some request or the other?
No, no. One book.
Passover is not possible. Tomorrow, yes, 56. At the request of respondent, and you please have to argue on the matter is called, yes. Inter-alia granted is extended. Yes. Yes. Because as you're seeing, the list is complete. Passover may not be possible. The list is marked tomorrow. Yes, next. Yes. Yes. Yes.
The petitioner is challenging the order dated 4/12/2021 by the lecturer Air Collects. Application filed by the presentation under section 311 of CRPC which came to be dismissed. Let's kindly see page number 37.
What is the impugned order?
Let's impugned order page number 37 words. Annexure F. He has filed application under section 311.
Application 65B.
No, that was allowed. On the strength of this order, I have filed an application for 311 to recall the RW1 to read further. For a moment, tell the similar. Page number 41.
No, first of all, tell the court where is the impugned order.
Impugned order at page number is it 44? 44. Before that,
No, let me read the issued order, then you can submit.
Minutes, before that, this is minutes.
It's a prayer to recall him and to mark the exhibits.
Please, before that, minutes, can you see minutes for a moment? Page number 39 minutes. Initially, minutes, what happened? The present petitioner has filed application under section 65B of the Evidence Act, which came to be allowed, and its permission was granted to the present petitioner to read his evidence as shown in the 65B certificate. Vide order dated 5/10/2021.
Yes.
Parliament changes in page number 41. Present petitioner has filed a minutes application for minutes under 65B to read his further evidence. The permission is granted for respondent to read his evidence as shown in 65B certificate. On the strength of this order, I have filed application under section 311 of CRPC to recall the respondent and read his further evidence, which came to be dismissed.
What is the purpose of allowing this application?
You see, what happens, sir? You are already rushing to the respondent in the cross-examination has asked.
Correct. If that is the case, what is the purpose of allowing this application? No, by virtue of this application being allowed, something is marked. All these CDs or whatever it is under section.
With respect to CD and WhatsApp chats, in the cross-examination one, the questions were asked to the petitioner. She has tendered all the suggestions.
Then why the court has done this later? This is on 13/10/2021. Then what happened? When is this application filed under for recalling? When did you file that application?
Page number 32.
Petitioner and counsel absent, respondent's counsel absent.
On 9/11/2021.
Huh?
On 9/11/2021.
Immediately.
Please, immediately.
What happened? Already you received the questions with respect to CD and chat subject.
That I understand.
Please.
Will you ask it before marking it or after marking?
You see, before marking only the questions were asked.
Then why the court permitted him to mark? Why a document will be marked? What is the purpose of it? Basing on the document, he wants to adduce evidence.
Because when the chief examination respondent also said they have not taken any steps to mark those.
Then why did the court allow it? Court shouldn't have allowed it, is it not? And you have not questioned it. Once the court has allowed that application and permitted him to mark a particular chart, he wanted to mark it for some purpose. And in that regard, he has to put forth the same or he has to cross-examine.
But you are still to 125 proceedings.
Then why did the court do? That's what I'm asking. Having allowed this application, it should be taken forward. If the court, while allowing this application, court should have said, this is summary proceedings, so all these things cannot be done. We will not allow this application.
But you are the application was only to obtain the 65B certificate. It can allow.
Let us see what is that application.
Please.
Let us see what is by virtue of that application, what is that happened. Come. So para number 4 at page number 41.
So the respondent is in the case of the
permission is granted for the respondent to lead his evidence as shown in 65B certificate. Then after that, what should follow?
Yes, follow.
Yes, file.
Yes.
So what is wrong in it? We'll allow it. Please come.
What else? Following the procedure of 65, it has to be marked. It has to make observation.
Yes. No, we will not go into any of it. That the court will take care. We are only concerned with what is the order passed by the court. Court says, no, the recalling is not required because 125 is summary. Then why need to do all this exercise? That's what I'll observe. Nothing more than that. Agreed with the orders passed in IA number, an order passed on an application under 311 CRPC, the dated 2/12, what is the date?
4/12/2021.
4/12/2021. You are the husband.
Husband.
The husband is before this court. Land counsel appearing for the land counsel appearing for the husband submits that earlier he has filed an IA. He has filed a 65B certificate with 2 series and prayed to lead further evidence and to proceed with the matter. That application came to be allowed by order dated 5/10/2021 immediately on 13/6/2020. What is the date? 9/11/2021. You said 13/10. No, it is.
Page number 30.
It was allowed on 5/10/2021. The matter was directed to be called on 13/10/2021. On 9/11/2021, he has come up with an application under section 311 CRPC with the prayer to recall him and mark the exhibits. That came to be dismissed by order impugned, wherein the court observes that it is not permissible because the respondent wanted to mark the CD through him. So only he should have done so during his chief examination and should have not waited for confrontation. Further, to decide an application under 125 CRPC, which is a summary proceedings, both parties need not go too much into their day-to-day talks and chats. The evidence under section 125 CRPC does not call for such evidence. Instead of marking the CD and the charts during his evidence, the respondent went for confronting it to the petitioner, and now he wants to turn around and say he wants to mark it from his side. The application is without any merits and dismiss the same. Next, land counsel appearing for the petitioner submits that the court ought not to have dismissed the application, having allowed the IA filed by him, wherein the court had permitted to lead his evidence as shown in the 65B certificate. Experal and counsel for the petition respondent submits that this application is filed at a faggot, and the court had rightly observed that under 125 CRPC proceedings all these are not required and no interference is called for. Next one. Having heard the counsels on either side, peruse the material on record. There is no dispute about the fact that the proceedings of the 125 CRPC are summary in nature, and a roving inquiry is not required to be done by the court. But in this case, the court had allowed a petition filed by the husband and permitted him to lead his evidence as shown in 65B certificate. Considering the fact that already that application is allowed, the court ought to have given permission to the petitioner and to mark the document exhibit. Considering the same, this court deems it appropriate to set aside the order dated 4/20/2021 and this order so and so, and accordingly the petition filed by the petitioner is allowed. Yes.
SCGP?
Excise matter for 16 of
I remember. Tomorrow, let this matter be on the top of the list tomorrow.
May I request it on day after tomorrow?
And day after tomorrow on the top of the list. Next 16.
Please, obliged.
Interim order.
16.
Then actually interim order.
No, I am not raising. I'll complete the list. Yes, 16.
No doubt I'm requesting for a brief time to file Wakala's matter. And for the respondent, ma'am.
Then comes to the respondents, it's time for filing wakalat. This is matter on 18th. Yes, next.
Please.
Still number 61.
Respondent, ma'am. Because on last year I was asked to verify whether they have filed an application regarding permission for DNA testing.
Permission for?
DNA test. Because there is no such application filed by them.
Then this has to go.
Because there's also.
There is no purpose. That's what she's saying, that you have not filed any application with the MC proceedings. Why should this be ordered?
In charity, this.
Correct. Your submission of your senior was that already they have filed an application. I asked him whether you have filed an application in the MC proceedings when you are questioning the paternity. He said yes. Tomorrow.
Yes.
It will be dismissed. Tell him.
Yes.
Yes.
And then, number 62. Prashant and Court. 88.
Milord, I am ready in this matter.
Yes, you are ready.
Come at 2:30, Milord. Plus a second. I also furnish the citation. The issue relating to the scope for retrospective withdrawal of the benefit by an executive
Tomorrow.
order.
We have it tomorrow.
Please oblige.
63.
Number 63 again. Still number 64 also. Still number 65. Chetan Gunodi.
Application under 7-11 has been dismissed. Brief facts of the case are dismissed. Father of the respondent and the purchaser.
What is the suit for?
Suit is one for partition and separate possession. Filed by
Yes.
son against mother and another against mother and mother's purchasers. On 28/3/2005.
You purchase the property.
I purchased the suit property from father of the respondent number 1. On 24/1/2013, father died. On 4/8/2020, present suit is filed for partition and separate possession.
4/8/20.
20. Suit is filed. In the entire claim development, there is no cause of action disclosed against me as a purchaser. In only one paragraph, paragraph number 6 was in page 22. I have produced the claim. In page 22, para 6, 6A, wherein specific government is made.
Sold the suit property in favor of the defendant number
Defendant number 2.
Which has made without knowledge and consent of the plaintiff.
Consent of.
And it is not binding on the plaintiff.
And-
What else you require?
Notes where when he admits that notes the father has sold the property to me. In next paragraph, he says plaintiff has demanded orally and requested on 2/6/2020 to the make partition in the suit schedule property mentioned, but defendant number 1 was postponed the same on one or other reasons. When there is a alienation made, question of defendant number 1 effecting partition does not
But
arise.
ultimately, the fact remains here, when it's a joint family property without the consent and without the other's consent, how can he sell the property?
In the year 2005, he has sold it.
No, but what happens is whenever it is sold, when it is a joint family property, the rights are there.
One request was, in this case, what has happened? Application was filed on the ground of cause of action. In fact, this was not the proper application which was supposed to be filed. It was supposed to be filed under limitation, holding that suit is barred by limitation. One request was, I am permitted to withdraw this application itself and file a fresh application, proper application.
Which year is this petition? 2022. What has happened to the suit from thereafter?
Suit is pending.
It is stayed.
See, it is stayed.
There is stay there.
It is stay. There is stay in this, and they are served and answered.
The present revision is filed. Agreed with orders dated 13th April 2022. Invoice in I number 3, invoice number 77 of 2010. The respondent herein has filed a suit for partition and also seeking a
No, there is no prayer. Prayer on stage there is no.
No declaration, they thought that it's not binding on them.
No prayer as such. No prayer as such. Para
Suit for partition.
partition.
The defendant, the purchaser who has purchased the property in the year 2005 has filed this application on order 7 to 11 stating that there is no cause of action for them to file the suit. The same came to be dismissed by order impugned, wherein the court has observed that
on two grounds, in fact, it was filed. There was one typographical error. It was harped upon, but that is not the ground.
that's the only ground it is filed.
Cause of action, that is also needed. There is no.
Where is that? Where is your idea?
Affidavit starts at page number 26.
20?
6 minutes, in page 26.
What did you say? There is ambiguity in the description of the suit scheduled property.
One line is a vague line, in fact, it was. Usually, page 27.
You said you have taken only two grounds. One is with regard to the ambiguity with regard to the property. And then,
Cause of action.
where do you get that?
Page number 27. The defendant number 2 submits that the plaintiff needs to disclose the real cause of action, and the plaintiff has cleverly tried to create an illusory cause of action that the suit
On two grounds, one is cause of action and other is about a disturbance in the school scheduled property. The court had dismissed, holding that already an amendment petition is filed, seeking to amend said discrepancy, and further the court held that there is cause of action. Then next parallel, counsel appearing for the petitioner has argued, reiterating the submissions that are made with the grounds that were taken before the trial court, and he also submits that the suit is barred by limitation. Next part. The notice is served on the respondent and no wakalat is filed. This court having heard the counsel for the petitioner, there is a material. Though before this court, the counsel for the petitioner has raised the question of limitation that was not the part of the application or adjudication that is done by the trial court. Whereas the other two grounds that are raised by him, the trial court had rightly considered and disposed of has rightly considered and dismissed the petition, considering the submission of the counsel. The order of the court with regard to the cause of action and the discrepancy in the suit scheduled property is concerned is upheld. However, the petitioner is at liberty, if he resides, is at liberty to move an application on the ground of limitation. Yes, next.
Number 66.
I'm for the husband.
Where is the counsel for the respondent? No representation. Tomorrow or day after?
Tomorrow.
Tomorrow. Yes, next.
Number 69. Suraj already.
At the request of the counsel and respondent, this is not a day after tomorrow. You are saying something.
Withdraw memo, serial number 11.
Serial number 11. Why you want to withdraw?
Matter is settled in both parties.
A memo is filed stating that matter is settled before the Lok Adalat on 27/3/2021. In view of the same, the petitioner may permitted to withdraw this petition, accordingly dismissed as withdrawn. Memo is taken on record.
Serial number 56, my lord.
56?
My lords have told tomorrow, my lord. 6 day after tomorrow, my lord.
56 day after tomorrow.
Yes,
Serial number 5. What has happened is before the honorable trial court decision.
No, what has happened today? Passover you asked.
29.
You are filing
I have
wakalat.
called wakalat. The case has become infectious because
5.
Yes, because the execution petition 1085/14.
Then counsel submits that the execution petition that's filed by the petitioner herein is already, the execution, the accrued order arises from the execution proceedings, and the execution proceeding is set for concluded. Hence the petition becomes infructuous, dismissed as infructuous.
In this, name of judge particularly deleted and mine is
What is your name?
Makbul Patil.
Delete the name of, it is submitted that so and so has filed wakalat, delete the name of Mr. Jagdish Patil. Yes. Amen. Signature.
Chambers matter.
2 o'clock.
Or